Hey, all. Good morning. Good morning. We're waiting to get started here. I got a busy day today. I'm heading over to LA federal court for the start of Tom Girardi's trial. The Real Housewives of Beverly Hills disbarred lawyer who's charged with 5 counts of wire fraud jury selection starts today. It's going to be a big one, but it's funny because this whole streaming of trials is just not universal. You should see the electronics restrictions on the Girardi trial. You're not going to be allowed to have anything in there. They're going to make you put phones in pouches before you go in. You can't bring in laptops. I mean, the whole concept of just live tweeting or live streaming an entire trial is pretty original, especially to the South. They do that all the time in the South. That's why you see so many trials from law and crime in like Florida. Georgia gets a lot of them. You see them in Wisconsin too. Wisconsin has pretty good open records laws, but federal court, you don't see that. And it's too bad because it gives, I think it's funny when people are talking about the Young Thug trial. They're like, oh, this is such a, harrowing look into the American judicial system. It's like, it's actually just the Fulton County, Georgia judicial system. Like county judicial systems are pretty different state by state. You see a lot more universality in federal court, but like LA Superior Court is pretty different from Fulton County Superior Court, just the way the district attorney's office operates, that kind of thing. But we can't see that stuff very often because we don't televise trials here. We don't stream trials, and we especially don't have anything like that in federal court. But I'm a little miffed because the judge on the Girardi case used to be in Orange County, and when she was in Orange County, she was totally receptive to stuff in court, electronics in court. I could live tweet in her courtroom. I could have my phone out. I could have my laptop, just like all the other federal judges in Orange County. But when she moved up to LA, she let it immediately go to her head. And now she does not allow any of that. But that's the Tom Girardi case. I'll be monitoring Young Thug from afar. They were saying that Potter, somebody from the DA's office, might investigate. But if you saw my live yesterday, I mean, I just sensed a sense and tone from her yesterday afternoon. Like, she obviously wants to keep this case going and move it along, but you can tell she is realizing how fucked up it is. Like, I mean, she's realizing the prosecution has serious problems. And this whole thing with the off the record discussion that happened, that the investigator from the DA's office confirmed happened, is a pretty big deal. I mean, I think that gave the judge pause. And if you just kind of listen to her tone, it's not sounding good. I don't know what that means for today. It's such a big decision that I'd be a little surprised if she did anything drastic today. But we'll see. It sounds like the idea that she is just going to dismiss this entire indictment with prejudice and make it so nobody can ever get charged with these crimes again. That's a pretty big decision, guys. And when you look through that indictment, I mean, there's a murder in there from 2002 that we haven't even heard anything about. The Shamel Drinks murder. I mean, the idea that she's going to make a decision that makes it so that charge is just dismissed with prejudice and the people who are charged currently cannot be recharged, I wouldn't count on that. I mean, that's stuff that she has to really think about. She's thinking about something, though. I mean, like I said, I really sensed a change in her yesterday, but this is such a big case and such a big decision that, I mean, the idea that a judge is just going to dismiss all these murder counts with prejudice, it's like, I don't know. We'll see what she does. But I really thought that the bombshell witness yesterday was long, and what he confirmed, especially in cross, about this off the record discussion, because Bumpus was testified the most, but anyone who watched, especially her cross and the questions that the judge was asking her, the judge didn't find her credible. I mean, the judge was totally grilling her, questioning her about all this stuff. So it seemed like sorry, figuring out the stream here. But it seemed like just on Kayla Bumpus's testimony, the judge would not have been willing to believe, without a doubt that there had been an off the record discussion. But then Long gets up there and basically does confirm it. Granted, it's not, Donovan, or it's not Woody confessing to Donovan Thomas's murder. And I think there could be a question about like what Brady material was actually in there. But according to Long, Hilton is the one who requested it off the record, which that right there is really, really not good of prosecutors doing that. And then she initiated the discussion with Bumpus saying, if he does say that he killed Donovan Thomas, we're going to charge him for perjury. So to have a prosecutor like initiating that discussion off the record, I think the idea that it's Brady material comes into, it could be considered an offer or like an agreement or a condition of his testimony that the defense should have known about. And I just, by how this judge has been, I think she could buy into that. And what's really going to screw the DA's office is requesting for that to be off the record. I mean, their own DA investigator testified that Hilton is the one who told the court reporter not to, like, they were coming back from a break and she wanted to have a quick discussion and told the court reporter, like, keep this off the record. And then it's like, that's really not good. And granted, it wasn't quite as explosive as, Brian Steele said he heard that Donovan Thomas that Woody confessed to Donovan Thomas's murder. And Adrian Love had questioned Caleb Bumpus like point blank. Did he say that he killed that? Did he say that he killed Donovan Thomas? No. So it's like, okay, we have that. But that, like, Brady material is so much broader than that, And for people who are tuning in, Brady material refers to, it's actually a guy named John Brady. He was a murder defendant back in the day, back in the late 1950s. And his case went all the way to the U.S. Supreme Court for exculpatory evidence. It's when the prosecutors have evidence that might exonerate you or make you look like less guilty in front of the eyes of a jury or really anyone in the public. But they're required to hand it over under that case. It's Brady versus Maryland in 1963. So a Brady violation, as they say, is when somebody doesn't hand over exculpatory evidence. But using the word exculpatory is almost a little misleading, because I think people who saw my interview with Max Shard heard him say that, some people hear that and they think it has to mean like somebody else's DNA proves that somebody else committed the crime. But really it can just be like helpful evidence. I covered a big case actually where I learned all about Brady violations in Orange County in 2017 and 2018. There was a mass murder. A guy went into a hair shop and killed 8 people. And there was no question that he was the one who did it. So it's kind of a question of how does anything after he did that.
Correct me if I'm wrong, but I believe that Ford is being proffered to support the position that alleged violations of the rules of professional responsibility are sufficient to support disqualification. For a couple of reasons, Your Honor, I just ask that the court allow us definiteness on what grounds the court will continue to hear motions to disqualify. I know that we started out with the witness, that we were a necessary witness, and then after the June 7th transcript came out, there were other grounds. And today I'm addressing the ones that have been proffered by the defense. But my take on Ford is that it, like Piedmont Hospital, which Ford cites, they're both obviously cases regarding civil matters. And I think, Your Honor, that it's interesting that both of them also involve conflicts of interest. There are cases within the state of Georgia that do involve disqualifying prosecutors in criminal cases. And of course, there are, 2 general grounds. We've addressed that in a previous response. But as it relates to this, our position is that all that Ford does is addresses whether two attorneys who appeared pro hac vice violated the professional rules. And it specifically authorizes the trial court to consider those rules when considering whether to revoke the pro hac vice admission. That is, the question was whether the attorney who is not a member of the Georgia bar would be allowed to practice in Georgia. And of course, that's not the issue here. Ford cited Piedmont Hospital versus Reddick, which had held that it was appropriate to consider the professional rules on a question of disqualification And one of the claims at issue in that case was whether an attorney for one party violated the professional rules when it contacted another party's board members and employees. And if true, that was something that the trial court could consider in a motion to disqualify. The Court of Appeals emphasized that the right to counsel is an important interest, which requires that any curtailment of the client's right to counsel of choice be approached with great caution. Disqualification not only curtails a client's right to counsel of choice, but results in expense and delay that are costly both to the client and to the administration of justice. And they go on to say that courts have been reluctant to disqualify an attorney despite misgivings about an attorney's conduct, perhaps because disqualification has an immediate adverse effect on the client by separating her from counsel of her choice. And that's Piedmont at 76 through 77. Finally, the court held that a party did not have standing to base a motion to disqualify an attorney to file a motion to disqualify an attorney based on a conflict of interest violation that did not involve that party. In Piedmont Hospital, the claim which was rejected was one entity's claim that an attorney was disqualified because of a conflict of interest where that entity was not in an attorney-client relationship with the attorney. Here, Your Honor, the state did not violate the professional rules of ethics. We didn't violate Rule 4.2A regarding communication with an unrepresented person. The court has heard the testimony of Mr. Melnick, and the court can gauge the credibility of the witnesses after Attorney Melnick informed the state that he represented Mr. Copeland. The state had no further conversations with Mr. Copeland about the subject of this case without either Attorney Melnick or Attorney Bumpus present. And in its response to Mr. Melnick's email, the state agreed it wouldn't communicate with Copeland further, but noted that we had arranged for transportation and that an investigator would pick Mr. Copeland up the following morning for his court appearance. That interaction was to bring Mr. Copeland to court as we had previously planned. For the reasons that we've stated in our prior filings, the hearings in chamber were proper. And even assuming arguendo that the court concludes otherwise, the state acted in good faith based on its understanding of the law. Indeed, at least 2 judges so far have concluded it was not improper. Disqualification is not an appropriate remedy under any event, especially given all of the circumstances here. We would ask that the court deny the defendant's motion to disqualify, and if there are other grounds, we would ask that the court, if they bring other grounds, we would ask that the court require that they list out all of the grounds that they're seeking so that we can address them at once, with Your Honor.
All right. Well, I think both Mr. Weinstein's and Mr. Shark's motions that are pending right now, Mr. Weinstein's for a mistrial and Mr. Shark's for a fair trial, set forth additional bases and suggest that as one of the potential remedies or grounds for relief. So I think the state has filed a response to Mr. Weinstein's motion on behalf of Mr. Kendrick. I don't know if y'all filed a response to the supplement, and I don't think I've seen a response to Mr. Shark's amended motion for a fair trial. So
That filed Friday.
yeah, that was filed Friday, and I'm not quite sure when the supplement was filed, sometime last week.
Okay.
So if y'all want to get something to me, can you get me something? When can you get me something?
Is Friday too late?
You can get me something by Friday.
Oh, thank you.
Okay. All right. And so I assume you have made the determination not to present any further evidence on that one issue about whether you whether the state was aware of the proposition that Mr. Melnick might be representing Mr. Copeland. Is that correct? Okay. All right. Yeah.
One more thing, we did receive the communication from Mr. Steele regarding proffers, and if an attorney rejects a proffer and insists on evidence.
With regard to Copeland or?
He said it generally. It may
Oh,
have
oh, yeah. Oh, okay. No, proffers from an attorney. Okay, yes. Mm-hmm.
And so to the extent that that is the way that that we would operate, we would to therefore require, if we're gonna put up evidence, we're gonna put it up. I don't know how the court views proffers, and I.
Well, I mean, I think that the case stands for the proposition that proffers are fine unless one party objects, in which case then you need to present evidence. And so
if that's the case, we would ask to any circumstance where proffers, we would, if we have to put up evidence, we don't want to be dueling proffers with evidence. If it's evidence, it's evidence. But for proffers are okay, I'm okay with that.
okay, thank you. All right, how about on the discrete issue of the phone calls, jail calls?
Yes, Your Honor. So I went back and reviewed what all we covered. So
Okay.
got through the 5 jail calls the state intends to introduce Mr. Copeland. And I also confirmed and spoke with Mr. Sharp, Mr. Steele. We were in agreement that we handled those jail calls related to Mr. Copeland on Friday.
Okay, I'm sorry, I just thought there were like 2 things outstanding that y'all said, let us huddle and then we'll get back to you.
Yes, Your Honor.
So I'm incorrect in that recollection?
In relation to the
Jail calls.
Jail calls, yes, Your Honor.
Okay, so, okay. Well, can y'all do me a favor then and refresh my recollection about what it was that was decided about the jail calls? Because I don't remember y'all putting anything before me. Did y'all just come to agreement, but y'all haven't told me what that is?
Your Honor, there was some that we agreed on. And there was, other parts where, like, for example, one of them was Detective Gaither. He asked if we could, basically we either agreed or redacted or argued those 5 calls. And it was at the very end on Friday.
Okay.
And I will get, Deputy Hilton had the notes from that, and so I will work on, and we'll get those notes from Deputy Hilton.
Okay.
That captures what all we discussed in our.
Okay. All right, so then moving on to our next issue. Yes.
Good morning, Your Honor. Good morning to everyone. I agree with Mr. Atkins, and we spoke last night. I think that the only outstanding issue on the jail calls for Mr. Copeland, the 5, was the redactions, and the court ordered us to look at it and then bring up any other issues with your court. So that's what I have.
And that's what I'm talking about.
And I think,
So,
yeah, but I don't think that the state or us have done that redaction yet. I think the state was trying to do it. If I'm wrong, Mr. Atkins, please correct me, but that's what I thought we discussed.
Yeah, and so right when we left court yesterday, when you and Mr. Shard spoke about the jail calls, and remember I had asked, we covered everything with it and we were in agreement?
Yes. That's right. And then the only thing we have to do is the redactions, and we have to look at them. That's my.
yeah, so I think that there was, I mean, I've got highlighted now, I made a ruling on those things. So, okay. So, but yes, there was still something outstanding y'all needed to do. So
Yes.
those 2 little pieces of redaction, I think. And y'all were going to get together on that and figure out whether you could come to agreement.
Yes, Your Honor. I will speak with Mr. Steele, Mr. Sharp, I guess there was some miscommunication because we spoke yesterday afternoon and thought everything was in order.
Okay.
I will speak with them expeditiously.
Okay.
and rectify
All right, thank you. All right, so then our next sort of big topic we need to sort out is what, if any, part and how we're going to handle the fact that Mr. Copeland gave testimony prior to the motion for recusal and then further testimony following the motion to recuse. And we all kind of agreed, okay, things that occur after a ultimately granted motion to recuse basically need to be redone. But if everybody can come to agreement as to, you know, these things, these parts of the testimony are okay anyway, then y'all can by agreement say these parts are okay and we can move forward. So have y'all gotten together now that I believe you have all of his testimony thus far to decide what, if anything, you think, how to handle it and what you think might need to come out, if any part?
Judge, we had been in communication with the defense, and I believe that the last time that Ms. Hilton spoke with Mr. Sharp, that they were representing that the defense would get together and see if they came to some collective understanding about what it was that they wanted to stipulate to and get back with us. But if I read correctly last night, they indicated that everything beyond the point of Mr. Kendrick's motion, they wanted to do over. If I read that wrong,
I don't know. I mean, if y'all had email communications overnight, I don't know what those would have said. But does somebody want to represent to the court what the defense position is, if it's a joint position?
Your Honor, I can speak on behalf of
as the third layer, and alternatively, we would join the motions on the floor.
Okay. So on the proposed limiting, I mean, jury's coming back before too much longer. So go ahead and get that to me and the state so that we can contemplate language and whether, I mean, I think it would be appropriate to give, so, but don't wait till the evidence is coming in. Give me a chance to look at it beforehand.
Assumes the evidence is coming in, and I don't make that assumption since the motions are still outstanding.
I'm trying to cover things in terms of eventualities and, you know, conditionally and things like that. So I understand that. I hope you're not chewing gum. Are you chewing gum? Okay, great. No chewing gum in class. All right. So it's my understanding that everybody has joined in the position that Mr. Copeland's testimony was coerced based on what occurred during the June 10th ex parte. So, and yet I know at least some of you want that testimony and said that yesterday. So are you waiving the issue of its potential coercion?
And good morning again, Your Honor. I am not waiving that
All right,
issue.
so then how do we handle that?
I thought it's two-stage. I was answering your question. If Mr. Copeland's resumes testimony, then my understanding of the rule is, or the law, is the way that the court announced, and I think all parties understand it, that once that motion by the Honorable Douglas Weinstein was filed on the 12th, everything thereafter is excluded and we redo it. And that's what we, Mr. Atkins sent an email last night. That's what three of us responded to. I don't want to waive, though, the issue. I thought we should have a hearing with Mr. Copeland to determine did that in camera, if it's in camera, ex parte rather, June 10th meeting, did you feel intimidated, coerced under the Archer case, which from Maryland, I know it's from Maryland,
Right.
that we discussed? And if yes, we were going to ask you then, if a witness was intimidated, that he should not have to test. If, you know, he could choose what he wants to do, and then we would strike everything. He
Okay,
said.
well then let's go ahead and find that out. I mean, can you get him here so that we can explore that issue? Because here's the thing is that, yeah, if you know, everything after June 10th, whether the recusal motion was filed or not, that's kind of a separate issue from whether his testimony post June 10th ex parte meeting was coerced. And if it was coerced, then what then? Do we, then how do we still say, oh yeah, but I want, you know, some of that testimony? That's still good.
I thought you, and listen, I have so many, you know, going on. It's just the reality of our case.
Yeah.
But I thought you said that either yesterday or last week, that we will find out whether Mr. Copeland actually wants to testify, continue testifying. And then if he doesn't continue testifying, my understanding of the law is then he would never have been given an opportunity to be cross-examined.
Right.
And therefore you strike all of his testimony. You give the command to the jury that wipe out everything that you heard, saw. There were writings introduced, all exhibits are struck. Give me your notes.
Right.
That's what I thought. Now,
Okay, I just didn't understand because, you know, and I thank you for clarifying, because what I was trying to sort out is, are y'all kind of taking the position it was coerced, you know, we have to redo all of it based on the coercion, but then also, yeah, we want to keep parts of it anyway. So if it's a yes, if it was coerced, then we need to redo all of it, or, you know, find out does he at this point kind of redo are you intending to take a stand and testify, or are you going to be held in contempt?
That's what I thought.
Okay, all right. Just so sounds like then we're on the same page. Just wanted to make sure y'all weren't wanting it kind of both ways. Ms. Levy, you look like you want to say something.
I was trying to get a full grasp, Your Honor, on everything that was being said. And when I hear that we're looking into whether or not his testimony was coerced, of course I'm going to defer to the court. I would object to that for several reasons. One of which is that the court has had an opportunity to review what went on there. And I believe that based on what is there, right there on the transcript, the court can see, and I believe could make a determination that there's not coercion. So based on the way that the witness has conducted himself, and based on the concerns that we have expressed, the concerns that the witness expressed during prior interviews before I even came onto the case, I would ask that the court not revisit or go back and see if have a hearing on whether or not he felt coerced.
Okay, so this isn't a revisiting of the issue because the issue is live and still pending before the court in Mr. Kendrick's motion and supplemental motion for mistrial, and in Mr. Shart's on Mr. Stillwell's behalf revised motion for a fair trial. That's a big claim in both of those motions. And I mean, I just gave you to Friday to respond to them, but and yeah, I think that on the record, it's a legal determination to be made. We don't necessarily need to hear from Mr. Copeland because I'm not sure about Mr. Copeland's credibility on anything anyway, but.
And so for those reasons, I would ask the court to not have us bring him in before that time that he has to testify. I'd also point out that his counsel was present.
I know.
Wow. So thank you for hearing me.
Okay, well, I mean, I hope that it is not up for debate that some of what was said to Mr. Copeland in terms of potential ramifications if he didn't testify was incorrect. I don't think that there was any kind of, purposeful or nefarious motive in that. But I mean, at least with regard to the notion that he could be held until the trial of even the severed co-defendants was completed, I don't think is a correct statement of the law. If you believe that it is, then please provide me with what you're basing that belief on. But I mean, I also don't think that he paid much attention to that at all. He doesn't even seem to have, he kind of basically moved on from that, but that was incorrect. I think that some of the assertions about statute of limitations potentially were incorrect. I don't think that with regard to he seemed to be worried about a particular crime, the statute of which had apparently already run. But I think that in terms of the notion that he faced no potential jeopardy with regard to crimes based on statute of limitations. I mean, there's the immunity issue, which is wholly separate, but y'all are basically saying you don't even have to worry about it for the statute of limitations reason. They're saying, well, then how are we sitting over here charged with RICO for crimes, the statute of which, when the statute has run on the overt acts, they're in support of the RICO. And I can't remember right offhand what the other potentially incorrect statement was about. But I mean, some of the this is or isn't perjury things are a little, I don't think quite exactly accurate either.
Okay,
So I mean, I guess what I'm saying is you run a lot of risk, even if I say it wasn't coerced, if that is the legal determination I make. I mean, I'm saying it's a really close call. And it might be better to just pretermit that issue and deal with it a different way.
okay, so when, that took me to the question I had yesterday, that I thought I had gotten completely wrong with respect to the, motion to compel that we had filed. Because it got to a point where he's trying to not testify. We would, of course, ask the court to compel him to testify. And the things that have happened. And he was, as I said, he was represented by counsel, as of course I already acknowledged. But I do understand what the court is saying, and I will respond to the motion.
Okay. But I don't want to be dealing, and I can give you to Friday to respond, but I don't want to be us having no idea what we're going to be doing Monday morning. I want it sorted out this week.
So,
And your motion to compel was filed when? To compel his testimony. I mean, that was, yeah. And the order was entered on the 7th. And I don't think there's any issue that can still be in effect. I don't think we need to redo that. If you want to redo it, and I'll consider it anew. But, I mean, the more prudent course would really be to just bring him in here like tomorrow and say, and if anybody wants to come up with, he's probably been advised ad nauseum about everything at this point anyway. But given that I just said, I think some of it's incorrect, a correct advisement of here's what the issues are, here's what you potentially face. And we're going to do it in court with everybody in front of us. Y'all can have some input on what he is advised of. Does he have counsel currently? I know he's gotten rid of Mr. Melnick and Ms. Bumpus at this point.
yes, that's correct, Your Honor. Mr. Melnick withdrew representation. His father was fired, so no one has said anything to us
Okay.
about a lawyer on his part. So we are unaware of whether he has any representation. And I'd also point out just that since he is still under that immunity grant from the state, it's my position is that anything what he testifies about would not subject him to criminal exposure. We can't use it. We can't go out and.
Yeah, and I agree that with regard to the immunity, he doesn't, but it's because of the immunity. It's not because there's some statute that protects, some statute of limitation that protects him from criminal liability. It's the immunity that would protect him. And he was not exactly accurately advised as to that, I don't think, at least potentially. Okay. So, I mean, I just think it might be cleanest to give him correct advice as to all of it and then find out what his intentions are. Would that work for everybody? Can I get an affirmative if that is in fact the case, not just a, like on the record, yes, if it's a yes.
I'll be back, Mr. Williams, yes.
Okay.
Yes. Yes, Your Honor.
Yes, Judge, with the caveat that no party, no state, even though they say it's our witness, not have any communication with that person. I was on the witness stand, which he still is, presumably. Thank you.
Okay.
And Your Honor, with respect to Mr. Harvey's request of the court, I would openly request that court allow us, because like we have had to transport the witness, I'd request in front of everyone that the court allow us the opportunity to continue transporting him, doing as we have been.
I mean, he's under your subpoena. Y'all are the one that needs to get him here, but no substantive conversations. Understand?
Yes.
Okay. All right. And y'all think you'll be able to achieve getting him here tomorrow?
Your Honor,
Can you get him here this afternoon? I mean, no, that's fine, but can you get him here tomorrow?
I believe that we can.
Okay.
And Your Honor, how much inquiry is the court going to allow, or examination?
We don't need to examine him about that. What we need to do, I think, is, given everybody has agreed, is just properly advise him as to what the immunity order means, what the consequences or potential consequences of refusing to testify regardless of the immunity order mean, and find out what his intention is. Okay, so I would love to get from y'all a proposal on what to advise him of. And let's let everybody kind of agree to it before we do it. And then it might not be a bad idea to have counsel for him. I don't know whether he's going to want to hire somebody, or whether he is, I mean, he's not a criminal defendant, so he probably wouldn't be entitled to counsel from the public defender's office, but maybe I can find somebody willing to take it on, whether he can pay them or not. I don't know.
So, Your Honor,
Suggestions?
Your Honor, when the court just said about compelling him to testify regardless of the immunity order, we wouldn't seek to compel it without it, because there's potential criminal exposure.
No, I know. I think you might have, I didn't mean to say that. The consequences if he does not testify despite the order. Any ideas about counsel? I mean, I think he's probably entitled to counsel if he wants it to advise him. I don't know. Hadn't done the research on that one.
Your Honor, on behalf of Mr. Williams and I think the rest of the defendants, it seems to me most appropriate for the court to at least inquire of Mr. Copeland himself, whether he is currently represented by counsel or not, and or what his intention is if he is not.
Sure. I mean, yeah, I agree. I guess I can't find that out before he shows up here.
I can have someone who just bring him in.
Okay.
Where he is, so I can actually ask.
All right. I mean, yeah, if we can find him, and even, I mean, I don't care if he shows up by Zoom for me to ask those questions, you know? I mean, that's fine with me. All right, so if he ultimately then says, yes, I'm fine with testifying, then does everybody want to start everything over, have me tell the jury, we're doing a do-over to all of it and start over with him? Or then do y'all want to agree to using some portion of what he's already testified to, some or all of what he's already testified to pre-recusal motion? I can't hear you. Y'all can think about that for a few minutes. Ms. Firstfields let me know that the 6/12 transcript, which was the last outstanding transcript of his testimony, has just been completed and is getting mailed out to y'all, emailed out to y'all. All right, so y'all think, ponder, and in the meantime, do we want to move on to the whatever motions in limine there are about Mr. Zachary? I think you said you had at least a good portion of that ready.
Yes, so, counsel for Mr. Stillwell sent over a series of redactions that they'd like to see made, but, we have objections to those, and so that is
Okay.
quite serious.
All right. That sounds good.
Would the court permit me to just step out?
Sure. Is Mr. Atkins going to take it from here while you're
No,
out?
I'm just asking him about Mr. Copeland and seeing if I can get him on the phone and get an answer to the court today.
Okay. All right, so the Zachary evidence, can somebody provide that to the court? Whatever we're going to be
Yes, Your Honor.
sorting through.
I'll send the transcript from this interview, Your Honor, and if any defense counsel objects, I can send what Mr. Sharp sent us so the court knows what
What we're walking through,
Yes, Your Honor,
that'd be great.
because it's broken down by numbers.
Okay, good.
And does the court already have the transcript?
I don't. No, but Mr. Atkins just said he'll send those.
And Your Honor, with respect to the transcript, they are uncorrected. There may be corrections that I make and then send to the defense.
Okay. Yeah, and maybe pick up your mic. And y'all, I'm trying, I think I told y'all yesterday, I'm trying to get longer stems for these, but
I didn't even turn my mic on, so I didn't even get through step one yet, so. It's now on and I am holding it. Mr. Atkins, Miss Love, Mr. Zachary's statement, his statement that I did not review yet or I've reviewed it, but I haven't given you the total redactions. Are you planning on playing if allowed, the part where he talks to the 18 feds about the guns?
It's possible, and there were two statements.
you should talk into the mic too, so everybody can hear you.
I keep remembering how loud I am. It is possible, and there were two. Yeah, I think yesterday when I spoke, I was expecting one more from you. There are two, the 2015, the August 2015 one, and then I think it's the March 2017 one. And we have your redaction request for the the August 2017 one. So do you mean for both of those? Or are you just asking about the March 2017 one?
The transcript doesn't, I don't believe, say what date it was, but the time he talked to the federal agents after speaking to Investigator Gaither.
And so when you say put it in, I wouldn't, outside of impeaching him, I wouldn't have a need to put in all of that. I would be asking the witness on the stand about that. So I can, with the court's permission, I can break away and talk to you about exactly what it is that you're concerned about.
Okay, well, I'm gonna send over my proposed redactions for the statement to Investigator Gaither with the understanding that I didn't list out any redactions for the discussion with the federal agents.
Okay. So you're sitting over the 2015 one? And then,
Yes.
okay.
All right, so there's one that has been done completely, the proposed redactions, right? So we'll just start on that one, and then I'm sure we'll have a morning break at some point. Y'all can maybe, if you need to huddle more on the another one, then that's fine.
Thank you.
transcripts of Zachary's potential, I mean, I guess it's statements over at Ms. Persfield or?
Yes, Your Honor, and I was gonna also inquire, we have an extra physical copy of the transcript, if that
Right.
works for the board.
Sure.
And then I will just email the redaction chart that we discussed.
Okay. Waiting on that to come through and then we'll get started. All right, do you want to hand up the
Yes, Your Honor.
hard copy of the transcript? Because I don't have the electronic one quite yet, but I'm sure it'll come through at some point, but we can go ahead and get started with the hard copy. Wow, that's a lot.
Copy of court can keep, but this teal colored one is gonna be what we're gonna discuss first.
Okay.
The red may come up later in the next.
Put the red to the side right now, then.
Perfect, Your Honor.
Thank you. ready with the first one on, that's, I guess, page 11, lines 10 through 12. Is that what that means? Or is that a timestamp?
Your Honor, that is correct. There was a couple Mr. Short had that, for the most part, I could follow. So if there's a
Okay.
discrepancy, I may ask Mr. Short specifically what
Okay.
line he
All right.
wanted, but I believe for the first one, that is correct.
All right. And is this mine to keep, this teal one?
Yes, Your Honor.
I can write all over it if I want
You
to.
can highlight it, write it.
Okay. All right. So, Mr. Sharp, the document that I'm looking at that says Quindarius proper session proposed edits, and it's all numbered 1 through whatever. Okay, so where am I supposed to be looking with regard to that first one? Because it's a lot of different numbers. I'm not sure what they all mean. Okay. I assume 11, 10 through 12 means page 11, lines 10 through 12, but then it has 10 again, which I don't know what that 10 is, and then
It should be when it ends. So it would be like 10, I'm pulling up my document.
okay. It is, I'm sorry. Go ahead with what?
So that first one would be page 11, line 10 through page 12, line 10.
Okay, that makes more sense. Gotcha. All right. And is one of the objections to all of this going to be these aren't proper under the co-conspirator exception?
Well, not everything that he says in these sessions is based on what arguably a co-conspirator said to him. Some of it may be, so some objections may be it's improper character evidence, it's irrelevant, things
Okay.
of that nature.
right.
But there is a lot of things that he was told, and quite frankly, Your Honor, there's some that I don't know him to have allegedly been present for something, and the source of his information is unclear. It may be rumor, it may be something he was told, and that is probably something that we're going to need to wade through at some point.
Okay. All right, so the very first one is, I'm about to tell you something, and I've just said I wasn't there.
That's in page 11, line 10.
Right. So it's obviously hearsay, so what's our exception?
Your Honor, part of it, when he's saying that he's at crucial,
No, he's saying I wasn't at Crucial.
when he's saying I was not at crucial.
Right.
And he can't speak about being at crucial.
Mm-hmm.
I don't have any objection to him, speaking about or trying to speak about being at crucial. I don't have any objection to taking that out.
All right, so are you good with the redaction of 11 line 10 through 12 line 10? Have you had a chance to look at these proposed redactions yet?
I looked at them, I haven't, synced them up with my transcript in my.
Okay.
recording. So, because I've read the transcript and listened to it so many times,
Okay.
I'm going through it with that knowledge.
Okay.
I haven't synced it up. I
Okay,
don't have any objections to it. Page 11, line 10.
all right, so that's out by agreement. All right, so that one's out by agreement. Do you want to, is it, if I gave you 30 minutes, could you decide which ones you agree to? Okay. Is there something else anybody needs to take up before we take our morning break and let Ms. Love do that? All right. Anybody else? Nobody? Okay. All right. We're just going to take our little morning break early. So we'll be back at 10:30. Agreement on anything?
Judge, I have just been reviewing Mr. Sharp's proposed redactions, and there are some that I agree to.
Okay.
Not a whole lot, but we've already given the court the first one. Does the court have a copy of his redaction?
Yeah, the proposed redaction, yes.
Yes. Okay, so looking at Mr. Sharp's chart, number one, we've already discussed. Number 17 is the next one.
All right. And that's agreed to?
Yes, I don't have any problem with that. That's the discussion of the search of defendant Williams' home, revealing a gun, and the gun and the contents of that search were suppressed, so that should
Okay.
not come in.
All
As well as number 19, which is on page 73 of the transcript.
right. All right.
That is, just to call it out, speculation.
Okay.
Specifically, it's 67, line 15 through 19. No, I'm sorry. Mr. Sharp has a description that is different than the lines that are listed. So 70, so on page 73,
Mm-hmm.
I don't have any objection to lines 10. He has it right, lines 10 through 13, no objection.
Ms. Lowe, could you just give me the number of the section you made no objection to?
17.
So 17 and 19, I also don't have any objection to. 23, I don't have any objection to.
Okay.
Could you clarify what the first one you did not have an objection to?
The first one that I did not have an objection to was number 1. And number 1, if you have, you already have the redactions? Okay, so it was Mr. Zachary, after saying he wasn't at Club Crucial, he talks about what happened at Club Crucial. And Your Honor, I will say that as it stands, I'm not trying to get that in. I don't know if something else changes, but right now I agree that it should come out.
Okay. All right. So we had gone through 23.
24, 25, 26, I don't agree with. Going to 27, it is 9211. Keep out. All the way through 9422. Ninety-two, 11 through 9422. That's what I've gotten to agree to. If the court permits me to further review the rest of them, because some of them I was looking and I don't agree to, I'm ready to argue those, or I can.
Let's do that right now. And then over the lunch break, you can go through the ones you hadn't hit yet and see whether there's agreement on any of those.
Did
Okay?
you, Did the state agree to 27 or no?
It's,
No. we
no,
stopped.
sounds like so far just 1, 17, 19, and 23. Okay. All right, so I guess that means 2 through 16, we need to take up.
Yes.
Okay.
And Your Honor, will we just follow the same pattern we did last time where the defense tells what their objection is?
Yeah, so I mean, the objections are essentially on the proposed redaction, so I guess the objections generally speculation about why they shot up the house.
So page 13, line 16 starts at Dennis talking with the witness about the house getting shot up. And this is following, I think you have to go back a little bit further to page 12 to get better context. In that conversation, the witness is talking with Deamonte Garlington about people that call him that night, starting on page 12, line 14. And Quamarvious Zachary is talking about his girlfriend telling him what's going on.
Right. Yeah, so it starts at 13, line 16. He doesn't have objection to him saying, hey, this house got shut up. It's why the house got shut up, which the objection's speculation.
So my argument, assuming I established the proper foundation, is that with Quamarvious Zachary saying that Trevante was helping defight. He's talking about Deamonte Garlington.
Right, so what would his basis of knowledge be? You would need to establish that he's got a legitimate basis to know that.
That's the point that I'm making. Like, without doing it, I wouldn't, if
Okay.
I were not able to do it, I wouldn't proffer it or even try to play
Okay,
it.
and so you think you can?
Yes, that's the point. Especially, Your Honor, when we're talking about, he goes all the way through to line 2.
Right, 14, line 2.
Okay, I was looking at line 14.
And
Unless if I don't establish that foundation, I won't tender that. But if I do, I just want to be able to play that part about his.
okay, so how about this? Right now, it's out on the, granted as to speculation.
Okay.
And if you establish it,
Okay.
then that'll be a different story.
That'll work. 14. Okay, so the next one being page 25. So 25, page 25, line 9 through 25:12 is a direct statement from the witness about an incident that's listed as an overt act on the indictment.
Okay,
And what they were doing, it's an admission.
all right.
It's an admission against it.
All right, so what's our objection there, Mr. Sharp?
My objection is drug use. And the character that's associated with that and the statement, they didn't, where is it? They really didn't care. That's speculation about someone else's mind state, or state of mind. The reality is, within this context is a story about that Mr. Zachary gives, that he describes my client, as well as others, shooting up houses. And I'm not, of course, I don't want that to be admitted, but that's a fight for another day. But I'm not objecting to that on any of these bases, but I am objecting. So I'm not objecting to him talking about that at this time, but I am objecting to him pontificating about my client's state of mind as this was going on, because he can't really speak to that.
So that would just go to they really didn't care part. And then you're saying the fact that he's saying they were taking Xanax is.
I don't know his basis of knowledge of that, but I don't believe that to be true, but I don't know his basis of knowledge of that.
All right, Ms. Love.
So Judge, my argument right now until I speak to him is that he is in the car with the persons that he's speaking to the detectives about. He has the opportunity to observe them up close. The question posed, as the court can see, is did they feel some kind of way that you didn't get out of the car? We believe that the evidence has shown and will continue to show that these people he's in the car with that are shooting up these houses are his friends. He's known them for a long time, and his personal observations of them and personal knowledge of them is what allows him to make the assertion that he does, that as to why they didn't care that he didn't get out of the car while they're facing arguably danger. They're the ones getting out, according to Mr. Zachary, doing the shooting, but they were high, essentially. So that's the reason why they didn't mind him not getting out of the car. We'd argue that it's intrinsic. It could go to why they would be so brazen as to do something like that. But the fact that they were high while they were shooting, the fact that it incidentally touches on someone's character.
Okay, so I don't have I don't think I'm going to overrule it as to character. And if you can establish that he actually knew they were on Xanax and high, that's fine. On the they really didn't care part, are you maintaining that part should come in?
Yes.
Because his observation is that
they didn't mind. He's offering up an explanation as to why. Basically, the investigator's a little bit incredulous that,
right. What's the motive? The motive's just they were high.
Yes.
All right. Well, if you can establish that he knows that they were on Xanax, then I will let you use that part. So overruled as to character and sort of like to be determined as to the basis of knowledge on whether they were high or not.
I put subject to foundation.
Okay.
So that is number. So the next one is further down. Mr. Zachary is asked by the prosecutor, what was you all's intention when you all headed over there? He says that we were going to kill one of the boys. And then the prosecutor says, and one of the boys, I know we talked about a bunch of names, but which of the guys were you looking for? And then Mr. Zachary responds, the request is to take out 17 through 25 all the way.
Yeah, I think just
I'm sorry,
17 through
25
17 through 20.
Yes, I'm sorry. So 17 through 20,
Right.
he's specifically talking about their intentions when they went on this shooting spree. I think that it's not only relevant, intrinsic, it gives a motive for what they were doing. He has personal knowledge of it. He was in the car. They were riding together.
Okay, well, as long as you establish that he knew that's what they were planning to do, and it's not.
And he doesn't say they, he says that
Oh,
we
he's-
were going to kill one of the.
Oh, I'm sorry. Actually, I maybe need to put on my glasses. Thought that said they were, but that we were, yes.
So, Your Honor, let me just back up. So this is an incident where houses were shot up. Mr. Zachary was charged, and in his proffer session, he's given testimony to try to get himself a deal. And I understand that's subject for cross-examination. My client was never charged.
Okay.
Mr. Zachary is throwing my client's name into this. And I understand that's subject for cross-examination as well. But when he says, what was y'all's intention?
Mm-hmm.
Now, it strikes me that Mr. Zachary can speak to his own intention, unless he says, Mr. Stillwell was there, and this is what Mr. Stillwell said, or something of that nature. He can speak to his own intention, what his intention was, and the state can ask him on the stand, Mr. Zachary, when you went over to the house, what was your plan? But unless someone else articulated their plan to Mr. Zachary, I don't think he's authorized to speak to what anyone else's plan was or intention was. And when he starts saying, and it's not his fault because
Of the way
Mr.
it's
Bailey
asked.
inartfully asked what was y'all's intention, and that prompted him to speak for other people.
Well, I understand, and it may very well be that you can establish that they all had a joint intention because they had had some sort of talk about it beforehand, or.
And they actually he reveals earlier in the interview that they do discuss it.
All right, so where's that?
So up. On line 4, he says, because he said we're not gonna shoot, how to do that to them. So on line 2, investigator Dennis asks, why does Muntung, and that is actually Antonio Sledge, it's spelled wrong, tell you not to get out of the car? He said, Mr. Zachary said, because he said, we don't shoot up houses, leave that to them. That's one point that they're talking. Further back on line, page 24, when Mr. Zachary is talking to Detective Dennis about the kind of guns that they have, he's naming them.
Okay, I mean, it does look like they kind of had.
Well, Your Honor, he's
Line 9.
talking about what Muntung said. Muntung's not even here. My client is not Muntung. And so I don't find respectfully what Ms. Love said to really address the issue.
All right, so where is it that your client gets, what is it that is indicating that he's talking, his speech includes your client if your client's not in the car?
No, my client is supposedly in the car according to Mr. Zachary. But what Ms. Love talked about is Muntung telling Mr. Zachary to not get out the car, saying, we don't shoot up houses, leave that to them. What that has to do with my client's intent to kill someone, I'm not seeing that link at all. And my whole point is this, Your Honor, if they can establish that that through Mr. Zachary, that my client indicated what the intent was, what the plan was, that's not in this transcript. That's going to come across through live testimony, which would render these prior statements, out of court statements, irrelevant anyways, because it would have been established through live testimony.
Right.
So I don't know why we would keep this in the transcript.
Judge, I thought that the whole purpose of this exercise was assuming that
Well,
they
it
don't.
is. It is. Okay, so assuming you need to use it as a prior inconsistent statement.
Yes, and in response to Mr. Sharp, Mr. Zachary is talking about his own intent and his understanding of what the conspiracy was. Arguably, this is a conspiratorial act of going out to shoot. We were going to kill one of the boys. So he does not, I don't think that it's improper for him to be able to talk about what the intentions of the group that he is acting as a part of were, as shown by their actions and their words throughout the course of the conspiracy itself.
But if it's just, if his statement is just based on assumptions he's making through the actions of others, then the jurors are in a similar place as Mr. Zachary to make that, to draw that conclusion.
But Mr.
So
Zachary,
I don't understand why Mr. Zachary, his conclusion about what my client's intent was would be particularly helpful or relevant to anything unless my client articulated it to him. And from my understanding of what Mr. Zachary's saying is he gets a call from his girlfriend Summer. Mr. Garlington and Mr. Sledge leave the club. Mr. Zachary doesn't know, according to his story, he doesn't know how Mr. Stillwell gets in the car because he wasn't at the club. And then they pick up Zachary last. And Zachary does not describe any conversation in the car on the way to these houses or anything like that. He doesn't give any context about communication. He's just kind of like, I got in the car and this is where we went.
so Judge, this is also the third interview that Mr. Zachary gave. He gave one earlier in 2015. This one occurred in 2017. So there are statements about this same incident in the 2015 interview as well. So we haven't gone through that one, but I could cross-reference that as well and provide those cross-references to the court. But the reality is that an assertion by a co-conspirator, if everyone is acting towards the same goal and people are getting shot up, houses are getting shot up, and
With assault rifles that are in the car.
right.
Yeah, I'm gonna overrule that. All right,
25.
28, line 17.
The
No.
font is a little small. I'm just having,
I'm sorry?
I need the court's glasses. I'm
Yeah,
just trying to
28,
get down.
line 1 through 3.
And with this one, Your Honor, I'm not trying to mislead anyone. If one of my colleagues tells me I'm wrong, then I'm wrong. My recollection, there has been no testimony about someone being shot in these houses.
Okay.
If I'm wrong about that, feel free to correct in this instance. The
So
shooting at
this
the houses.
one, we have given the list of 30 witnesses, and one of the first witnesses after Mr. Zachary is the young lady who lives at this house and her sister
Okay.
getting shot at. So there hasn't been,
Did somebody get shot at this house?
yes.
And that evidence will come in through this other, what's the name of that witness?
Miss Bell and her sister Cecilia.
So they're coming to testify?
I see him on the witness list.
You don't see them?
Yeah, I do. I see Denise Bell. I don't know what the other person's name is. So you intend to call somebody who says somebody at this house got shot?
Yes.
Okay, so then that is all right. All right, number 6. And I guess let's make this 3-page proffer of proposed edits, a record of part of an exhibit to today's proceedings. So in the event of an eventual review, whomever is reviewing it will know what we're talking about when we say on to number 6.
Can we make, you don't want us to use the one we're writing on, you want to make
Yeah,
it,
I mean, just a
easier.
clean copy.
Okay.
Yeah, I know we're all writing on ours right now. So yeah, just a clean copy, and it can be,
We can do that.
I don't care who makes it an exhibit.
Okay.
It's basically just for purposes of the record. I can make it a court's exhibit to today, court's exhibit 1. I'll print out a clean copy right now. All right.
So the next one is page 29, line 10 through 29, line 11. So going back, Your Honor, you can see from page 28, line you can go back up as far as line 7, but you'll see that there's context. You want to pause?
No.
Okay, you can see that there's context. Mr. Zachary is talking about where they went, what they did. And at line 18, he's talking about the house on Oak. And later on, you have Investigator Dennis talking about his familiarity with the house.
Right.
The fact that he offers a concrete fact, his knowledge about the house, and Mr. Zachary doesn't correct him or doesn't say anything about it, I would argue it just
How would
goes
he
to the
correct him
effect.
to that?
I mean, it's not something that by itself is very material. There's just,
Then take
I
it out.
don't,
Strike it. Granted.
you're, okay. Out.
All right. I'm just writing August 6th, 2024, Courts Exhibit 1, as to this 3-page
Yes, Your Honor.
proposed reductions. Okay.
So the number 7 is page 33, line 1 through 35, line 14. That actually starts back up on page 32, or actually 31, where Mr. Zachary is talking about Trevante. So page 31, line 16, where Dennis says, got it, you were sitting behind Monkton, Deamonte is in the back with you and Shannon is in front, and then and then Mr. Zachary says they were in another car, yeah. And they go on and talk about that. My argument is that the portion that they're asking to keep out is all information Dennis is exchanging with Quindarius Zachary about activities that YSL and rivals are sort of involved in. Mr. Dennis talks about how they thought it was Kale, and Mr. Zachary says, no, he corrects him, no, and then Dennis says, well, enlighten me, and he's like, no, you go ahead. But Zachary later on line 17 says they tried to say that we did it, acknowledging that there is a we, acknowledging in a way that helps to prove count 1 in our indictment. There is a they who is an opposition group who tried to say that we did it, we being YSL.
Where is the part where the opposition group is saying they thought we did it? I see the investigator saying, we thought y'all did it, but.
No, line 17, where he says they
Oh.
tried to say that we did it, on on page 33.
Oh, it's back on page 35. I'm sorry. Okay. Okay. And so this would be to establish,
The existence of the enterprise, the gang, and the fact that there is an opposition and a they and a we.
all right, Mr.
So,
Sharp?
I mean, that's not factually accurate.
Okay.
On this.
Pull your mic towards you, if you don't mind.
On this
It
alleged.
moves, so you can just move it up on your desk, maybe, I don't know.
with
I
this-
know, they're all annoying, they get in the way.
With this alleged incident, the shooting up the houses, Mr. Zachary also puts a gentleman, two gentlemen, a Trevante Turner and a Tay, as being in the caravan with them shooting up these houses. Trevante Turner is sadly deceased. He has never been, I've never heard anyone allege that he was a member of YSL. The paper just reported that he was associated with, I believe it was If Gang.
I'm
but
not sure I'm gonna go on what the paper says.
I understand, but the state has never alleged that. He's not charged in this.
Okay,
This is a gentleman who, has not, there's been no allegations that he's been affiliated with us. I believe that there's a suggestion that he's a friend of Kenneth Copeland's, but that's it. So I don't want it to come in, but I don't have a legal argument at this point against them. Mr. Zachary saying Trevante Turner was part of this mission that he's claiming
mhm.
existed. But at the times that I highlighted that I have a problem with, it's talking about a wholly unrelated incident where Trevante Turner, who's not one of us, and Shell Kell, who is Kelvin Watts, were having their own side beef and shooting at each other. And I believe Trevante was shot maybe by Shell Kell. Mr. Watts was maybe shot by Trevante, but it has nothing to do with this indictment. It's not alleged as an overt act, and it has nothing to do with, if I were to, for the purposes of this argument, agree that there's a group called YSL and it's a criminal street gang, which obviously is an issue here, this incident would have nothing to do with that. And it's just talking about, and they're just really treating it as small talk, that he's telling a story and then it's a little aside about Trevante, which has nothing to do with this case.
All right, Ms. Lett, what do you have to say about
So-
that?
We had served in discovery a PowerPoint that involves, just as it relates to the assertion by Mr. Sharp that Trevante Turner was not associated with YSL. And in that PowerPoint that we served, we reflect on one of the slides at January 27 of 2015 incident 15-026-2801 on Stanhope Circle, where shots were fired, specifically where Trevante Turner was shot. And it's listed that he is an associate of YSL/30D. Just to go to the assertion that there's never been any indication about Trevante Turner being YSL.
Well,
But
an
that's-
associate of YSL and a member of YSL aren't the same thing.
They aren't, but I'm not asserting one way or the other as it relates to associate or member with respect to Trevante Turner. What I'm saying is that in saying that they tried to say we did it, Quindarius Zachary, when we charge the gang act, associate or member, it doesn't matter. Associates commit acts with the gang. So it doesn't in any way cut against, is my position, my argument that in saying they try to say we did it, he's not just talking about a random group of men. He's talking about them as a group that operates as YSL is the argument that I would make.
Well,
Who's the they here?
The person,
Go ahead.
she does.
so
All right, let me,
so if gang is the gang that
so
they're
is that the they here? This is the
associates
part of the gang that
yes.
there's the alleged beef back and forth and the
Yes.
series of shooting, the members that are involved in this little, even if it's a side incident, are all that gang?
Yes.
Okay.
Well, if that's the money line, they tried to say, like, how's that admissible? They tried to say we did it. I mean, false accusations by an unnamed group about something that the declarant, in this case, Mr. Zachary, is actually saying they were wrong about. How's that admissible to anything? You know, and if that's the key section, that's inadmissible in itself. But I think this whole section is just wholly irrelevant, and it confuses the issues.
And if the court goes on further down,
Mm-hmm.
and investigator Dennis elaborates, that basically you all were laying in wait for Kelvin Watts. It says Watch, but it's Watts, W-A-T-T-S, Shell Kel, who also has a gray Charger. Just in the continued conversation with everything he asserts, he is making an affirmation about the existence of the gang itself. Yeah, that's what they say. Is what Quindarius Zachary says. He's not pushing back against the notion that they would be laying in watch for Shell Kel. He's just saying, yeah, that's what they say. There's an acknowledgement still of an opposition and of a group that he belongs to.
All right. So,
He's literally saying, no, that didn't happen.
right. But she's not offering it for whether it happened the way they said it happened or not. She's offering it for the concept that Mr. Zachary is saying, yeah, there's this we here that is YSL, and that is certainly relevant to the issues in this case. And if you want some kind, I mean, if it even comes in, because I assume, this is all if he doesn't testify as the state thinks he will, and then they have to impeach him, although, it would be interesting to see how you use this and what you would be using this to impeach for. Because if your purpose with it is to establish there's a we and a they, then he'd have to testify inconsistently to that for you to be able to use this. Do you understand?
Yes.
Okay.
And Your Honor,
And if that is what you're able to then use it for, I mean, I'd be happy to limit that this is only for the purpose of that, and it's not for whatever may or may not have happened with regard to some side shooting incident.
And let me just say that in his statements, Mr. Zachary, in his statements, and if he testified, I anticipate, he doesn't deny that there's a group called YSL.
Right.
He doesn't deny any of this. So I don't think that these issues are really.
Yeah, that's what I'm saying is this one may be one that never materializes, because I would say this is potentially admissible as impeachment on the issue that you're saying you want it for, not anything as to whatever this actual shooting is. Understand?
yes, and
Okay.
my understanding about the exercise overall is just to identify those portions that just absolutely cannot come in.
Right. So I don't want you up here saying, so, hey, tell me about this time that, you
Right.
and whomever were involved in this shooting with the, and whatever it is.
So unless, right, I understand fully. Like,
Then
in
he
other words,
says something
don't try to
different, you're
get
like,
him, don't try to impeach him just to get in some ancillary, otherwise inadmissible thing.
Correct.
Yes.
Okay. All right, moving on.
Number 8 being page 36, lines 1 through 30.
I'm sorry, I haven't read it all, but if it is gang members being happy because Gaither's not working anymore, how's that relevant?
So, Your Honor,
Yes.
I would argue. But I can concede that and say that there's really not, I can let that one go. I
Alrighty.
can stipulate to that.
Okay.
I just like it.
And, Your Honor,
And that,
I think I may have made an error on that. 36, 1 to 24 is certainly about that. I'm not certain 37, 8 to 18 is about that same thing.
Okay.
I thought we were just doing the 1 through 24 first.
Yeah, all right. Well, I mean, he's got it all as number 8. So,
Okay.
all right. So agreed that 36, that part is out. So turn into 37, 8 through 18.
So in 37, 8 to 18, as I understand it, they're trying to identify Tay, and they're showing picture of Tay with a car, and they're saying, is that the car? And then investigator Underwood and Dennis and Zachary are agreeing, no, that's not the car. That's the car that got shot up by another person named Kel. It's just about Tay's other car that was not involved in the April 28th, 2015 shooting up houses being shot up. It's just
Okay.
talk about another car being shot.
All right. Is
Has
that
nothing to do-
relevant?
So, Judge, in context 37, Mr. Sharp's objection goes all the way into page 38, unless I'm reading it wrong.
No, it's 37, 8 to 18, right?
Correct.
Okay. For now, Judge, I can stipulate to that. I don't see any reason to keep that part in right now.
All right. So that is also out by agreement.
And Your Honor, should anything, and I don't anticipate it, but should anything come up that causes me to ask the court, hey, there's something I agreed to that I need to get in now because.
Let's
this
not wait
happened.
until the last minute to do it. Okay.
It would only be by virtue of something happening on the stand.
Okay. I mean, can you imagine a scenario why it suddenly becomes relevant that some other car that,
It's not the car being shot up, it's Mr. Zachary giving the description of the individuals and his knowledge of certain individuals.
Tay?
Mhm. And
Okay. So
and
that's
boy called
lines
Kale.
3 and 4. Is that Tay? Yeah.
And 16, where he's talking about the other boy called Kale. Those sort of instances. I don't foresee them being necessary, but I didn't want to not say to the court, hey, this might come up.
Okay. Well, so maybe if there's some issue as to who Kel is. Okay.
And then I think that the next one on number 8 is all of page 38.
Yeah.
It's 38, line 8 to 39, line 11.
Hold on. 38. Line 8.
Okay.
Through 39, 11.
Really to 39. It's
Through 39, line 1.
the end of 39.
Okay.
Oh,
It's two different incidents. It's a discussion about people saying on the street. Again, I'm just trying to clean up this transcript. It's just going to be confusing to people. I don't care if all sorts of bad things come up in against about Tay one way or another.
Right.
But I'm just trying to limit confusion that the
Right.
jurors would have. And they're talking about people on the street saying that Tay shot up Rich Homie Kwan's dad's barber shop. Rich Homie Kwan's
I have no
father
objection
is a
to-
barber and runs a barber shop.
All right. She may
Oh.
not, she may agree.
I have no objection to 8 through with the clarification that he made, because I thought it was the whole page.
Okay.
So I have no objection to 8 through 24
Okay.
of
So,
page 38.
all right.
And then on 39, uh, 30 to 39:19, 1 through
39.
19.
39, 1.
39, 9 through 19, or
1
just
through
all
19.
one? Okay.
I have no objection to 1 through 13, where he stops at,
Okay, so 13 is the end of the Rich Homie Kwan
right,
barber shop. And then they
yes.
start talking about Tay shot Kel.
And
I don't represent Tay. Tay's not associated. So, but it's just I just think it would be
Alright.
confusing.
Why is it?
Tay is associated, that's what we were just talking about, Tay being Trevante.
Right. Who is dead and not on trial here, right?
That's true, unfortunately.
Okay. So is it relevant?
In it,
I mean, I would assume you want a clean, clear story to the extent you can have one as well. So is this relevant to the story the state is attempting to tell?
yes, it goes over into page 40. There's a video that we're gonna have about with Quindarius Zachary, Antonio Sledge, I think Demekion Garlington, and they're saying they're talking to Shell Kell, who is Ifgang, and I think that they have a gun. That's my memory, that they have a long gun, and they're saying we ain't going back and forth, and they're saying disparaging things.
Mhm.
And it's over a girl named Antrevia Smith. And when the court sees Tree in this transcript, they're talking about Antrevia.
Okay.
So to the extent that we're talking about one associate or member of YSL, Trevante, and we're going on into the fact that Antonio Sledge and Shell Kell were seeing Antrevia. We're getting into information that we've noticed the defense that we're gonna introduce anyway. So I don't know why this would not.
I don't know or understand the nexus between Mr. Sledge threatening Kel on social media over a common girlfriend and Tay shooting Kel. I mean, I'm not talking bad about the guy. I think there was probably a lot of people that had problems with Mr. Kelvin Watts, and
We'll take it out.
Tay shooting.
All right, they'll take it out.
We'll take out. So it's gonna be 15 through 21.
All right, so we already agreed to 39, 1 through 13. So I think this would start at 14. 39, 14 through what?
14 through 21.
I have 4215. It bleeds into number 9. I think that's why I was unclear. I made it its own separate one, this issue.
Wait, what now?
To number 9 on my list is the continued discussion about the beef between Kel and Trevante, and they start out with Trevante shooting Kel, and then they talk about how Kel allegedly shot up Trevia's house. Again, something that I don't believe that the police believe is true. That was Mr. Zachary
We don't.
saying his understanding was that Kel shot up his girlfriend Trevia's house.
All right. Hang on. Ms.
So-
Love.
In as much as Mr. Sharp said that the police don't rather believe that Mr. Zachary's line about Kelvin Watts shooting up Entrevia's house, that part is correct because Entrevia Smith relayed to police when she gave them that video that Kelvin Watts was in the house with her. So in as much as Quindarius Zachary is attempting to push responsibility from what we believe is one member of his group to a member of the opposition group, I would think that would be relevant. It wouldn't be the first thing that I would ask him. It's something that I don't think is inadmissible, but it's also something that at this time, we're going to talk to him. We've noticed the defense about our intent to talk about when Entrevia Smith's house got shot up. It's just not every line of this portion that Mr. Sharp has labeled number 9. We may not get into every single line there, but the topic itself is what we did notice them that we're going to introduce evidence of.
If they bring up shooting of Trevia's house, that's one thing, and that's, it may or may not be relevant. But my issue, and I don't agree with the state's characterization about Mr. Zachary lying about it. What we're dealing with here is not Mr. Zachary lying. Mr. Zachary wasn't at Trevia Smith's house. Mr. Zachary was not shooting at Trevia Smith's house or being shot at Miss Smith's house, Trevia Smith's house. Mr. Zachary is passing on rumors that he's heard through the grapevine about who did what, and the police are saying, well, we don't believe that's accurate because we believe that Shelkel was in the house. So how could he shoot up the house? So it's whether it's a relevant topic or not, it's all based on hearsay that Mr. Zachary has no firsthand knowledge of.
Excuse, Judge, I just point the court's attention to the first line of page 41. And I'd also point out that Mr. Zachary was in that video that Entrevia gave over to the police after her house got shot up. He was in the video along with Antonio Sledge, where they were threatening Kelvin Watts.
All right. Let me ask you this. Could you take a closer look at the rest of 39 through 42 and maybe sort out what part of that you think, if he doesn't testify as you think he will, you would use to impeach him on a relevant issue? And then maybe get back to us on this one?
Yes.
Okay. Because I mean, I kind of hear you saying, even you think not all of it is anything you would want or need. Okay.
And that's all the way through 42.
All right. So.
So the next one is number 10 is 42. line 17 through 44, line 6. What is it? So when the objection is lack of personal knowledge, I am laboring under the assumption that Mr. Sharp's belief is that Mr. Zachary lacks personal knowledge. I would just ask that the court allow it, because it's all opposition actions towards one another. Shell Kell shot up the gambling house. On McDonald Boulevard, Dennis asks on page 43, line 1, that's when Thug's car got shot, right? I believe, if we haven't already, I believe that we have we've touched on that there was a shooting where his car got shot. But it may have been with Kenneth Copeland and some of the stuff that we have to redo.
Right.
But Mr. Zachary is saying, yeah, shot up Thug's car. Thug wasn't studying it. All of that information, maybe not like that, but that information we anticipate bringing out. So to the extent that Mr. Sharp objects and has as his basis lack of personal knowledge, I would just ask that the court find that it's admissible subject to the proper foundation being laid for it.
I'm okay. That seems reasonable if you can lay the foundation.
Okay.
Yes.
Okay. Okay. After consulting with others, we're going to withdraw our objection.
Okay.
All right.
All right. So I'm gonna take that out.
All right. Number 11.
45.
That should,
15.
number 11 should be 46, line
Okay.
15.
Okay.
46, 15 through 16.
Yes. Well, maybe I'm wrong. I'm wrong. It was supposed to be 45. I'm sorry. They're all talking about an unrelated, they're talking about a girl named Clenethia Rant. And then Mr. Zachary just says she's dead. And then they talk about the circumstances of her
Okay.
murder.
I don't have
All
any
right, that- she
objections to that
agrees.
part coming out. Mm-mm.
Okay.
What's her name?
So
That's
that's
45, 15 through 46,
Yeah.
16. I agree.
not
Okay,
number 11?
let me interrupt y'all a minute. I have word that Mr. Copeland is here and available right now, so why don't we pause what we're doing with this and have him in, see if he has an attorney, see if he wants an attorney. We don't yet have anything put together that I'm going to advise him of, but
I'm good with that.
we
part.
could get through a little bit more of this, tell him to hold tight, take a lunch break where y'all can come up with something. But I could at least find out about the attorney issue right now.
I think that's
Okay.
Judge, please come in.
Hi, good morning, Mr. Copeland. I'm Judge Whitaker. I think you've been before me before in unrelated matters.
Huh?
I'm the judge taking over this case now. So go ahead and have a seat. What I want to ask you right now, I know that you have been given immunity with regard to your testimony. And there had been, at some point, you didn't want to testify. At some point, you did want to testify. The first question I have for you.
I never wanted to testify.
Okay, the first, well, right, want to is maybe the wrong term, but my question for you right now is, do you have an attorney at all?
I don't know.
You don't know whether you have an attorney? I would think that would be a no then, if you don't know
I
whether.
was saying, I was talking to Melanie, but
Melnick?
yes,
Okay, didn't he ask to be relieved as your attorney, and did you sign something saying that's okay, you can get out of this?
I don't.
You don't remember? Okay. Does anybody know whether that actually occurred?
I don't believe it occurred.
Okay.
I believe that Ms. Bumpus,
I know she was stand-in. and
she was standing and I believe something was said on the record to the effect that Ms. Bumpus was relieved. But
Yeah, I know
don't-
she was,
There was
but,
nothing about Mr. Melnick to my knowledge.
okay, maybe
There was, Miss Bumpus actually said yesterday, I believe, during her testimony, that Mr. Melnick had directed her to tell Mr. Copeland that he could either exercise his, that he
well,
could do
choose
one
not to
thing,
testify.
right? Or if he chose to testify, according to Miss Bumpus.
Yeah, I remember she said, there's this paper I'm supposed to get him to sign. I'm trying to figure out whether it got signed.
So I never got Mr. Melanie off my case,
Okay, so he's still your attorney then?
I guess.
Okay, all right. Well, then that's the answer we've got for that. All right, so I'm going to try to get a hold of Mr. Melnick and see if he can be here with us this afternoon, because some of what I suspect you recall when you were brought into Judge Glanville's chambers with Ms. Bumpus and a couple of the people from the state. And there was a discussion that Ms. Bumpus and Ms. Hilton and Judge Glanville had with you. You asked some questions. They gave you some information. Some of that information was not actually factually correct. And I want to make sure that you have the opportunity, understanding what it is that the immunity order means, understanding what the potential consequences are if you do testify or if you don't. We're basically going to kind of start over and
So
do
if I
that
don't
over.
testify, so if I don't testify, how long you gonna hold me in jail?
So, I mean, that's still an issue that you can be held in jail through the end of this trial. But I'd rather have Mr. Melnick here to advise you about the potential drawbacks of and benefits of what, if there are any,
This
of any
trial
of
right
your.
here? To the end of this trial,
Yes,
not the other people.
not as far as I believe, but the state. What did you want to do? Some further research on that?
Yes, just to advise the court
Okay.
of.
Okay, so I just wanted to know, first off, do you have an attorney? Because if you do have an attorney, then your attorney may have some information, advice, and research for me about that. So I want to make sure that I tell you the correct thing about that, okay? So we're going to take a lunch break in a little while, and why don't we plan to have you back here on standby at least. I don't know who was in communication, but we need to reach out to Mr. Melnick, see what his availability is. So just be on standby in case I need you here like at 2 or 3 this afternoon.
2 or 3?
Yeah, because we're about to take a lunch break before too much longer. So you're okay to leave for the next couple of hours, but stay where whomever reached out from the state can reach you to let you know whether you need to be back here this afternoon or potentially tomorrow instead, okay?
All right.
All right, thank you. So, I don't know who. Okay, my litigation manager is going to reach out to Mr. Melnick, see if he can get a hold of, see if she can get a hold of Mr. Melnick and find out what his availability is. And depending upon his availability, we'll just see when it is that we have Mr. Copeland back. Because I want him to have the benefit of counsel. And then I also want y'all over the lunch break to work on whatever you think ought to be the correct advice to him. And if you, the state, believe that it is possible to hold him past the trial for which he is under subpoena, then you show me what authority
Yes, Your Honor.
lets you believe that. Okay. All right. Yeah.
One thing, I think that the transcript reflects this from June 10th, and as well as Ms. Bumpus's testimony yesterday.
Mhm.
She was emphatic that Mr. Melnick said, if you testify, I'm not representing you. So, and with the fact that Mr. Copeland said,
No, what he said was, if you plead the fifth, I'm not representing you. So I don't know, what that means. I'm just going to reach out to Mr. Melnick, and at least Mr. Copeland thinks Mr. Melnick is still representing him. And if Mr. Copeland never signed whatever that was relieving him, I don't know exactly what their arrangement is, but let's find out from Mr. Melnick.
yes, Your Honor.
All right. Okay, so let's get a few more minutes in of this before we break, because it's not even noon yet, and we were making some progress, which is good. All right, so we were on number 12.
Number 12 being page 47, lines, if I'm reading correctly, line 14 through page 50, line 8.
Yes.
Okay. So, Your Honor, the objection to this portion of it, just to give you a little bit of background. So, this fight happened around January the 6th, and it did begin with Mr. Copeland, according to the reports from our investigators, but it involved more than one member of YSL, more than one alleged member of YSL. Mr. Bloody J, who is a member of If Gang, was on the other side of the fight from YSL, and other people who are in the courtroom now participated in that with them. So Mr. Zachary's rendition of what happened, we would argue it's Mr. Zachary's knowledge of and participation in this gang is what allows him to be able to tell this to Detective Dennis. Mr. Sharp's assertion, it does not appear that he was there, I don't think is a ground to exclude it, assuming that the court is satisfied with the foundation that the state lays for Mr. Zachary's
Being
ability
a
to
co-conspirator.
Yes, we would argue that it's admissible. It's
So do you know whether he was there or not?
So
let me ask Mr. Sharp, is the basis for you saying you don't think he was there that no on line 23 when Is that the basis of it?
What page, line 23?
47, line 23? Because I don't think that no is actually an answer
Oh,
to.
no,
Okay.
it's not based on that.
Okay.
I
You have no
actually
reason
do
to
not
believe.
know.
Okay,
I actually do not know
Okay.
he was there, and I haven't heard anyone talk about him being there.
okay. Do we
And
know whether
and
he
this
was
is-
there?
Page 48, line 5. Start at line.
Oh, so we went back there. Yeah.
Okay,
Okay.
if he was in fact there, then.
And then
I withdraw.
somewhere else, he says, would he, okay, all right, well then you'll withdraw that objection?
If he was there, then yes.
Okay. So that number 12 is withdrawn. All right, number 13.
My understanding is this is page 54, line 18, through page 55, line 11.
Yeah, let's take that up first.
So the state has no objection to page 54, lines 18 through 22, where investigator Dennis says, who they say killed him, meaning Donovan Thomas. Zachary repeats the question. Ultimately, Zachary says, shoot, they say Woody and them, I don't know for a fact. So I would agree and argue that you don't know.
Okay,
So it's
He's
not,
telling them,
okay. So 54, line 18 through 22, you concede should be redacted.
so, and let me also give further clarification. Mr. Zachary, later, he tells earlier in 2015, he relays to law enforcement about statements made to him by 2 people in the courtroom now. And 2 people admitting having killed Donovan Thomas.
Okay,
This statement right here is after 2 years later. So, when he says, they say Woody and them, I don't know for a fact.
mm-hmm.
If somebody argued that that's an inconsistent statement that should come in, I'm not objecting to it coming out because what I feel is a lie is irrelevant, but I'm not objecting to it coming out.
Okay,
so, Your Honor, we got a lot of moving parts here. Because eventually, I agree with Ms. Love. Eventually in this statement, Mr. Zachary claims that Mr. Kendrick told him that they killed Nutt and Mr. Stillwell told him that they killed Mr. Thomas.
okay.
So I anticipate, because, I was doing this for Mr. Stillwell, but I anticipate other counsel in this courtroom arguing that are affected by this, arguing that this is spilling the beans and it's not a statement by a co-conspirator and therefore not admissible.
Which part are we talking about?
Okay.
I think,
Okay. So, right. Okay.
okay,
So, if I guess I'll rewind. I will say that if there is testimony, either through direct testimony or cross-examine or impeachment,
mhm.
that my client said something to Mr. Zachary, or that Mr. Kendrick said something to Mr. Zachary, then I would want to get that in.
18 through 22.
Right, because it would be inconsistent with the claims he says later on. Here he's saying, well, they're saying Woody and other people,
All right,
but
I
then
don't know.
later on he says, my client directly said this.
All right,
So if that comes in, I'd want to use that for impeachment.
I'd have to know who the they is here. right? Before that could be, if the they is Mr. Kendrick or Mr. Stillwell, yes. But if the they is some random amorphous gossip rag,
Well,
no.
it would be relevant because if he's telling the truth, okay, assuming he's telling the truth.
Oh, I see
He is
I see what
holding-
you mean.
Yeah.
If he's already said, or he will later say.
He's going to say that he already said in a different statement, and later in this statement, he's going to say that my client told him
Okay,
at night. And if he's holding that information, then him answering, they saying will be, and them, I don't know.
all right, I still need to find out who the they is then, because the question posed by the investigator is who they say killed him,
I think.
right?
Ask
So,
who the streets are saying.
okay, well then, for Mr. Zachary to say, here's what the street is saying, is not inconsistent with, but I actually know because the perpetrator told me it's the perpetrator. So that would not be this 18 through 22 would not be inconsistent to a statement by Zachary that Mr. Kendrick and or Mr. Stillwell told me personally that they're the ones that did it. You see what I mean?
I see what you mean. I would argue that that would be the time a reasonable person would say, who they say did it. Well, if my client had said he did it, say, well, I don't even need to tell you who they
All
say.
right, well, I would reject that argument. So that's out. All right, so next. Is what, 20, page 54, line 23 through 5511. Is that all going to be the same
That is all.
chunk of whatever? Okay.
So we're starting at page 57, line 22.
No, 54. Because all we dealt with was 54, 18 through 22. It goes all the way through 55, 11. So, okay, you was with them at the condo afterwards. I was there. I mean, that,
All of that, we would object to it being redacted out. All of this is, Mr. Copeland talking about.
okay, so, all right. The,
Not Mr. Copeland, Mr. Zachary, my apologies. So I don't know how.
okay, so now I'm seeing Mr. Shard as I read on further. He's going back to the, well, that's what they say. I don't know for a fact.
Right.
I see what you, I mean, I hadn't read that part before. Who did they say? God, I don't even know if we're talking about the street here, because you was with them at the condo afterwards. I was there, but shoot. That what they say? I don't know for a fact.
Right.
I'm saying, who did they say killed him? He may at this point mean, who did they, the people you are at the condo with, say? So can anybody actually point me to who the they is? If I flip back far enough?
In this particular interview, no, not as it relates to.
Oh, good
this
Lord.
statement right here. Because it's one of those.
It's all over the place.
No, it's, as it relates to the way that Dennis is talking to Zachary.
Yeah.
He means it just like if I were to just pop up and say, who did they say did it? There's no they identified.
Is there a video of this?
Yeah.
All right, I may need to watch the video of this part, because maybe the inflection will let me know whether he means, let me watch the video on this. Can y'all send me that and then give me a timestamp for this part? Let me revisit that whole thing, including the 18 through 22 part.
If you send, I don't know if you have the times marked, but if you send the video that shows Mr. Zachary's face kind of zoomed in, I think it's an MP4 video. I think it's right around 27 minutes, 30 seconds.
27 minutes, 30 seconds.
I
Okay.
believe so.
Thank you.
Per my notes.
Okay, thanks.
Are we gonna move, to the next one or just?
Yeah, no, I'll take a look at that offline unless y'all got it queued up right now. I'll take a look at that offline if y'all will send me that video. So yeah, if 5722 through 23 is a separate kind of issue, we can move on to that one. All right,
I have 3 digits. I know it's meant to be a typo, probably. Is it just 5722 or 5723? Because it has 223.
I think so. Your objection, Mr. Shart, here is 57 lines 22 and 23.
I'm going to withdraw that.
Okay. So that one is not objected to. All right. Moving on to number 14, which is page 60, line 19 through 61, line 20.
So, Your Honor, this is.
I'm going to withdraw that one as well.
All right. Okay, then our next item is on page 65, lines 8 through 20.
We're on number 15.
Yes.
It's, and my objection to this is just incorrect rendition of the law, explaining, Investigator Dennis is explaining to Quindarius Zachary why he's guilty by association.
Yeah, and I suspect he was not offering that as here's what the law is. He was offering that as here's what we law enforcement consider you to be, but
Right.
I can understand that. You wanna agree to that, Ms. Love?
Judge, is the court will give me, my counsel is sitting here whispering in my ear, the court will give me 1 second.
To get there and consider it, yes, I will give you a second to do that.
I'm here in the court.
We'll see. I'll give you about 10 more seconds to make your decision. I'm just gonna make my ruling.
I don't object to 65-8 through 65-20 coming out.
All right. So that is out by agreement.
And Your Honor,
Yes.
yeah, I don't have any objection. all of number 15, and number 16 starts at 366. Line 12 through 66, line 18 is what I understand. Your Honor, this is one of the acts that's listed as an overt act in this indictment. As I'm reading it, page 66, line 12 starts out talking about the gun that Mr. Zachary got caught with on May the 7th, and then investigator Dennis goes on to say the assault rifle you're in the video with, and he's saying what it came back to. And then you have Mr. Zachary saying that's Moon's gun. But he is acknowledging that he and Mr. Sledge, who the state alleges, Mr. Sledge already pled, but Mr. Zachary is indeed YSL. So they're swapping guns. We would just argue that this is evidence of count one and the gang count in this case.
That's not my issue.
Count one.
Okay, so do you have an issue with lines 8, lines, where is it? 12 through 18?
I do have an issue with 12 to 18. I don't have an issue with him saying that he gave the gun to Moontoon or that's Moontoon's gun. That's fine. What I have an issue with is saying with investigator Dennis, saying that the ballistics from that gun matched the May 7th shooting of Lucci's Bennett's
Okay.
mom's house. And there's a couple reasons. It's not been put in evidence
Okay,
yet.
well, hang on. Maybe we can address your objection and still have in the portion that Ms. Love wants it for
So
by
it's really 16.
redacting a smaller part of it.
I should have said 16 to 17, if I was
Okay.
to be more precise.
Okay, so any issue with just with redacting out 16 and 17, Investigator Dennis's statement about it having come back to that?
Not for the purposes of Quamarvious Act. No objection at all.
Okay. So. So that's 66, 17 through 18. Out by agreement. Okay, and next we move to 68, 24, and 25.
It's,
I was.
Yeah.
We're asking.
I don't, Mr. Sharp, did that have some issue?
right, 60, they're going back to Lucci mom's house, and then they're saying the gun you got caught with has something on it until you didn't know it until you went to court yesterday. So I think that should come out 6819.
Okay, so then maybe we just aren't lined up with
Yeah.
line numbers.
Yeah, that's
So 68, 19 through 21, right?
I would say,
25,
because then they go to Lucci mom again.
well, 24 maybe?
Right, okay,
Okay, right?
yes.
So 19 through 24, out.
And then
All right, hang on, let's make sure that we've got agreement on that.
So when 19 through 24, so that's page 60.
It's page 68, lines 19 through 24. Do you agree? It's basically the same issue.
The issue that I have here is that I would object to that because Mr. Zachary admits that it has shooting on it. You know, it's is one of the guns used in one of the shootings. So, even though, as it relates to the previous portion that I
Uh-huh.
agreed to, and arguably even with the previous portion, the effect on Mr. Zachary, him not denying that or him not expressing surprise, but instead saying, oh, that's no Duke's gun. In this particular case, when Dennis says what he says, Mr. Zachary doesn't say, what? Oh my gosh, no. Instead, he says, it has shootings on it. Yeah, it has some shootings on it.
He says that because they told him in court the day before. He didn't know.
But Judge, Mr. Sharp can't be the witness in this particular instance.
I'm going by what the transcript says.
I'm saying though that he can't speak to why Mr. Zachary said, yeah, it has some shootings on it.
I'm gonna exclude that. I mean, honestly, it looks to me like he's saying, yeah, I mean, now that I know, I'm not surprised, but I mean, if that's what you wanted in for, make that argument, but I didn't hear that argument, so that would be lines. So you're saying, hang on, Mr. Sharp, on 68, where are you proposing that redaction start?
19 to 24.
19 to 24, okay. I am gonna exclude that. All right, now moving to 69, lines 2 through 6.
And it's starting on January 26th, halfway through too.
Okay.
Through 5 really.
Was that page 69, line 2?
Yes.
Yeah, lines 2 through 6, starting with on January 26th. I mean, they're basically again saying, hey, you had this gun at some point and we know that it was involved in this shooting. We'd like to know who gave you the gun. And they don't have an issue with, we'd like to know who gave you the gun. Just we found out later this came back to the shooting.
That's fine.
Okay, so that is 2 through 6, starting on January 26th, are out by agreement. Okay. And then 17 we already did, so the next one is actually 18, page 69, line 25 through 7213. And
Okay, so Judge, when Detective Dennis asks who shot up Lucci's mama's house on page 69 at line 25, and Mr. Zachary gives them an answer. I would argue that all of this is information that I should be able to ask him about. And if he doesn't, if he testifies inconsistently, it should be able to come in. I'm not looking at his reason for asking it to come out, so.
yeah, what's your
There's no indication.
how he knows?
To the extent that my client was there, as he claims, there's no indication that he was there, and there's no indication of what his source of knowledge is. I think he's just passing along rumors. And so if he says, I was there when Lucci's mom's house was shot up and it was Shannon Stillwell that did it, then I don't really have a leg to stand on, but I don't believe he's going to say that. And he needs firsthand knowledge or another exception or another hearsay exception. And I don't see it in the state just kind of saying, oh, well, he knows, so therefore it's admissible. There's just so much rumor and back and forth in this case. And I think that the investigators, I'm not trying to criticize them, but they're just trying to like gather information, not in preparation of trying the case, but just trying to get like some broad generalized what the word on the street is.
So, Your Honor, as with any evidence or testimony that we elicit or tender, we have to establish a foundation before it's admitted. So we would not be seeking, and this we don't believe is just rank hearsay. So we just have a different position, and we would ask that the court just allows the opportunity to lay the foundation and present it.
All right, and I assume that your foundation is going to be co-conspirator exception, that they all know this because they're in the gang and they communicate and they need to be able to know that argument. I mean, I would think so. And frankly, even on 73, when they asked about what about Doug's stepdad's house, he actually says, I don't know for sure who did that one. So, I mean, he's clearly, if he doesn't know, he's like, beats me on that one.
Well, I think, I don't speak for Mr. Zachary, but I could see a world where he's a layman. And so he's saying, well, I haven't heard, I don't know for sure means I haven't heard anyone, no one's told me about that. And I don't think the co-conspirator, and I'm not saying that Your Honor said this, but I don't believe that the co-conspirator exception is satisfied by just saying, oh, well, it was a bunch of co-conspirators talking. I think that they need to establish who said what to whom and where in the circumstances of that statement, so we can see if it falls under 801 D2E. And
Well.
so that's, I'm in the blind right now as far as how the state plans to get into that. But what I don't want to happen is the state, when Mr. Zachary's on the stand, to try to bring up, well, who do you know who shot Lucci's mother's house? And he says, I don't know, I wasn't there. And then they say, well, didn't you tell the investigators that Woody and Shannon and Pokey did it? And it's like, it was just based on nothing, but it's already out there now.
And Judge, that would be a leap. That would be to say who did it and then didn't you tell them. I would at the very least establish a basis for his knowledge, either from things that he has said previously or from things that he says on the stand. So it wouldn't be as if it would be some kind of backdoor way to get in somebody's name that, you know, is sitting here in the courtroom. It would be the proper pulling out of evidence of the witness on the stand. It would be establishing a foundation for his knowledge.
Okay, but we're assuming if this comes in, that it's coming in because it's coming in as an inconsistent statement, you're impeaching him, right? I mean, obviously, if he gets up and you ask him about it and he testifies to all of it on the stand, then there still might be a foundational objection, but then we deal with that then. But if you're getting it in because you're having to impeach him, that's what we're trying to decide now. And so I don't want to wait and have the jury there and make the jury go away while we figure out the basis of his knowledge, you know?
Yes.
So I don't know if you, we'll swing back around to that one. Okay. Let's see. I mean, and frankly, it's probably going to be the same. You're going to need the same information for a foundation, regardless of its as to his testimony on the stand or as to this, you know. But yeah, it kind of let us know what that's going to be. so that I can make a determination of whether it comes in, potentially.
Which number are we on?
Well, that was 18. You agree about 19, so we're moving to 20. And y'all just let me know when lunch gets here and we'll break. Oh, it is here? Okay, we're gonna break then. All right. Great. So it's 12:15 right now. So far, Ms. Rosser has not been able to reach Mr. Melnick. So, it's probably more likely that it'll be tomorrow than today. So why don't we, I don't know, maybe I'll know more after lunch, but let's break until 1:30. Is that enough time, deputies, for getting everybody fed? Okay. See y'all back at 1:30. We got everybody? All right. All right, what I know about Mr. Melnick at this point is that he is going to be available by Zoom 3-ish, and he was going to, I didn't talk to him. My lit manager talked to him. So I'm not sure we have a super clear answer on whether he currently represents Mr. Copeland, but Mr. Melnick was going to reach out to Mr. Copeland. And maybe by the time we hear from Mr. Melnick at 3, we'll know the status of that representation. All right. Yes. Am I cold? Is the court cold? No, the court's never cold because these robes are really heavy and hot. So no, but I mean, I realize that it is probably objectively a little cold in here. So I might nudge it up a half a degree for y'all. And then if y'all, hang on. Now, there are 2 other thermostats somewhere in this room, and if y'all want to nudge those up, somebody just go back there and do that. That's fine. Okay. All right, so we were, I think, on item number 20. Were you able to look through any more of them? And
So what I was doing was the other assignment, which was to look up the law and to look up what we should tell Ms. Copeland. I don't have.
oh, perfect. Yeah, that's probably more pressing. So, okay. What do you know on those?
So I'll start out with just the fact that the language of the statute itself is part of the basis, well, actually was the basis for the interpretation that we had regarding.
Okay, let me get maybe to the statute. Give me a second to get on Lexis. Unless you have a copy of it for me.
I don't have.
That's fine. It'll just take me a second to get it pulled up. So you're talking about 24.5.507?
Yes, Your Honor.
Okay. All right.
So just the plain language of the statute, so just the plain language of the statute, Your Honor, which is essentially a statute, not saying that the court can grant immunity, but that the state can grant it and we have to move the court. It lays out very specific steps that we have to take. And in.
Hang on a second. Can you not hear her?
Yeah.
All right. Can you, I don't know, do those mics move?
It wasn't on.
Okay.
It wasn't on.
There we go.
So as I was saying, the language of 24.5.507 lays out very specific steps. Only the state can grant immunity, but the court can compel the testimony, which we obviously can't do. And 245507 is a statute that allows us the leeway, the grounds rather, the pathway to get a witness to testify after they have pled
Right.
the fifth. And so section B of 245507 says, if a person refuses to testify after being granted immunity from prosecution and after being ordered to testify as set forth in this code section, such a person may be adjudged in contempt and committed to the county jail until such time as such person purges himself or herself of contempt by testifying as ordered without regard to the expiration of the grand jury. I don't know why it only references the grand jury and not a petite jury, because the top portion of the statute in section A refers to both. And it talks about the fact that if you're needed in a criminal proceeding before a court or a grand jury, if your testimony is deemed by the district attorney necessary to the public interest, then the DA may ask the court to compel that person to testify. In any event, the last line, which says that if the grand jury before which such person was ordered to testify has been dissolved, such person may purge himself or herself by testifying before the court. I don't have the reason that they refer to the grand jury and don't reference the trial jury. But given the fact that the statute itself refers to them almost interchangeably in section A, when they say if you're either brought before the grand jury or a criminal proceeding. And so the fact that even after the grand jury is dissolved, the court can keep you there until you purge yourself of the contempt by giving the court testimony. The extrapolation that I made was you can be kept until you purge yourself of the contempt by testifying, because you don't have a right to assert your Fifth Amendment privilege.
Right. So one thing I would wonder about with regard to that argument is it's sort of a kind of basic canon of statutory construction that if certain language is used in a part of a statute and then it is not used in another part, that there's a reason that it's not used, that there's some significance to at one point saying before a court or grand jury, because they clearly knew they could use different language. So the fact that they didn't include it all in the second part, there might be a reason for it. So that I think kind of cuts against the argument that I can hold Mr. Copeland throughout all three trials. So I think we need, if there's some sort of case law that indicates that if the testimony at issue is before, like for a trial, that somebody can be held even after the trial is over until such time as they decide to come testify in front of a court about it. So
someone sent me a case, but I haven't fully got it. It's in re long 276 Georgia App 306. I'm reading it.
Okay. And if anybody on the defense side of the room's got a case that says the opposite, then that would also help us out. You know, that answers the question the other way. It just seems to me like if he's under subpoena for a trial, then the point in which it would logically end would be when the trial is over. And I get he may never still purge himself of the contempt, but
and in reading. And it's a 2005 case, Judge, so I haven't looked carefully at it, so I don't know if it's cited in the annotations?
It is for a different proposition. I haven't read it myself either, but. I don't know that this case really answers the question we're asking. Anybody have any other kind of case? I mean, my position without a case to say it clearly one way or another is I sort of feel like it couldn't go past the end of the trial.
But it doesn't say.
But I know that. I mean, one way or another, I'm willing to be persuaded differently if we've got law.
Your Honor, having a case on point, however, it would make logical sense that it couldn't go past the end of the trial. How would Mr. Copeland purge himself of contempt at the interim time between two trials?
Yeah, I mean, I guess the same way that they suggest that if the grand jury is over with, you can come purge yourself by testifying in front of the court. Not that either of those really achieves the end that is sought by the immunity order, but it's a way to purge. But, you know.
And arguably, the testimony would be under oath and available. I'm
It was not going to be available at, I mean,
not at that trial.
Right.
Unless, yeah.
so I'm sort of going with through the end of this trial unless somebody tells me differently. All right, has anybody come up with anything else that he ought to be advised about?
Now, I know that the court did advise him that. Westmoreland, can you hear me? I know that the court advised him that he was told some things that were not entirely accurate. And just listening to the testimony and looking at the transcript of what he was told, as the court sits now, are there particular points that the court has concerns about? Because regarding perjury, the statute sort of lays it out. And I know that before he testified the last time, Judge Glanville, I think, gave him a copy of
Ms. Bumpus to give to him, I think.
No, actually, while Mr. Copeland was on the stand, I think that,
in court.
yes,
Okay.
he gave to Mr. Copeland read to him or gave it to him a copy of the statute and apprised him. I think he made
Right. But all of that was before the ex parte. Y'all, it's already too hot, so I'm gonna have to turn it back up.
Okay.
But I went up a whole degree, so I'm seeing if a half degree will make a difference.
I will survive. So
what were we saying? Oh, yeah. So that was in court, but then the ex parte occurred after that.
It did.
And much closer in time to when he ended up testifying. So I'm thinking that probably was well, who knows, but that may have been the thing on his mind at the time. So one thing, and I mean, there's, this is he comes in on page, at 10:03, and it goes until 11:30. And I mean, there may have been a break or two in there, but so I realized that it's not just he's told one thing at one point in time, and that's really unclear. I mean, it may be that the gist of it gives him the right information, but for instance, I know there was one thing about perjury that I didn't think was exactly accurate. Just as an example, if I can find it. Okay, so on page 51, The example, and I know what Ms. Hilton means. I don't think that anybody is purposefully trying to mislead anybody. I think we're all, you weren't there by the time Mr. Copeland came in, but I think Ms. Bumpus, Judge Glanville, and Ms. Hilton were trying to make sure he understood. But Ms. Hilton says, your example that you gave me, what if I said I did something and I know you didn't do it and you said before you didn't do it? That's not perjury. That is a prior inconsistent statement. Well, I mean, yes, it's a prior inconsistent statement, but it might also be perjury. It might not be, but
Yeah.
I mean, yeah, there'd have to be some, proof that it's a lie. But to say that's not perjury is technically not necessarily correct. And you're also talking to a layperson. And he clearly, I don't think, understands. I mean, he even says, I don't understand any of this at the outset. And, we're talking about purge versus perjury. And I just think we need to make sure we give him clear instructions and then he can make a decision.
Yes, Your Honor. And I know that I think I said on the record regarding his attempt to sort of get that information before he took the stand, when he was trying to speak with Ms. Hilton out there in the foyer area.
Yeah, and then, we also discussed the immunity versus statute of limitations. And yes, the immunity, because he has been given immunity, protects him from being prosecuted based on anything he says, if he says anything. And that is true. But he was also sort of told, you don't have any statute of limitation worries either. And that's not necessarily true. And it may have no practical effect because if he can't be prosecuted, he can't be prosecuted, even if it's for something within the statute. Right. But it was technically not necessarily 100% accurate information. Whether he in any way relied on that, I'm not saying that at all. But I just want to make sure we do it entirely, to the extent we can, correctly and accurately.
So would the court be inclined to read him the statute and then respond? I don't know. I'm asking. Respond to questions because, for instance, I even heard, it may have just been a misstatement, obviously, and people communicate differently, but when Mr. Melnick was saying regarding how his testimony couldn't be used, but we could use the testimony we can't.
So I don't know. Some people keep saying he's got use, and then some people are saying he's got use and derivative use. So I probably need to look at the order.
I wrote the order and I literally modeled it after the exact words in the statute. Like I took the statute and put it in the order for the most part. And so the part of the statute that says that no testimony or other evidence required under the order or any information directly or indirectly derived from such testimony or evidence shall be used against the person in any proceeding or prosecution for a crime or offense.
That sounds like derivative use to me.
And so that, that was in there from the start. And
all right. And yeah, do you want to, I can, what's the perjury statute?
I will look it up.
And frankly, I'm not sure that either giving him or reading him any of these statutes is going to be particularly helpful, but that's why I would like for him to have counsel, so counsel can explain to him, here's what the perjury statute means. Here's what your immunity order means. Here's what a prior inconsistent statement is. Here is what you face if you decide not to testify regardless of your immunity. And then, sure, if he has any questions of the court, still we can entertain those. But
and I don't know how wise it would be to even make the request that if his counsel seeks to understand the extent to which the immunity exists. Like if he would speak to us, but
Well, maybe we
Can
can
you-
dial down from all of that too. That's been several weeks since y'all all made, assertions about whether or not, who knew what when and who was professional and who wasn't. And maybe we can, I'm going to ask Mr. Melnick and you to move past that. And
I'm beyond it. I would.
you're beyond it. Great. We'll see if he is.
And I would endeavor, I would love to be able to fully explain, to allay any fears that he has or concerns about his
Sure.
client's criminal exposure, but 161070 is the perjury.
Okay. And then I ought to know prior and consistent statements by heart, but which one is that? 24 something? I don't know. I'm sure I have it in front of me somewhere, but I think those would be the four relevant things: the order 507, perjury statute, and prior and consistent statements. Whatever, I'll figure it out later. I can find prior and consistent statements.
24-6-630. Wait. Twenty-four, 6-6-13. Witness's prior statement. 24-6-6-13B.
So Ms. Persfield's been doing some research, and at least the federal statute on contempt related to kind of their version of immunity is that the confinement can't exceed the life of the court proceeding. So that's sort of, I know we're not the feds, but.
Is court proceeding the indictment, or is it the trial of a severed, because if people are severed? Like,
I don't know the answer to that.
Judge.
Yes. Yes, I don't, who said that?
On that side.
You did what? Say that again.
Email.
Ah, okay, to Ms. Persfield, okay. And do you have a short answer for me?
Yeah, we don't just hold people in custody. As U.S. Supreme Court cited in the footnote 1 from the Middle District of Tennessee, our issue is a deposition. The person refused to testify. There were trials coming up. They were not set yet. The government's position is like the state of Georgia.
Government's position is like the state of Georgia here. Just hold the person because the case is not resolved. And the Middle District, the district court judge gave reasons. And in the footnote, they gave the U.S. Supreme Court that the contempt is punishable for this trial. And after that, we don't do for other trials that are not set. And the government can't continue the same contempt over and over again. They can bring an obstruction of justice indictment against a person or a contempt criminal charge against the person, but we don't just hold people because it becomes, and there's other cases I can send you, at some point it becomes just punishment. The whole point of civil contempt is to coerce the person to do the act.
Right.
And at some point they're not doing the act.
Yeah.
Otherwise, according to Ms. Love, I mean, really, according to Ms. Love's reading, we could just hold them until it's 50 years later. Yeah.
Yeah.
I mean, at
Which
some
can't
point,
be the law.
Judge.
And I know you're not arguing that,
Could
but
the court permit me a moment to just review the case that Mr. Steele just sent over?
sure. Did you send
I
it to
got it.
everybody?
He did. I got
Okay,
it.
yeah.
I just want to read it.
And Judge,
Mr. Matthews.
Similarly, is civil contempt, and I'm looking at in re estate of Banks. In re estate of Banks is going to be 339 Georgia App 144. It says under Georgia law, when the trial court orders incarceration for an indefinite period until the performance of a specified act, the contempt is civil. A trial court, however, may not continue incarceration for civil contempt when the respondent lacks the ability to purge themselves. Imprisonment under civil sanctions is always conditional, and a party found in contempt may apply for release at any time upon a showing of inability to comply. The moment it appears that there is inability, it would clearly be the duty of the judge to discharge the party, because the purpose of civil contempt is to provide a remedy and to obtain compliance with the trial court's orders. The justification for imprisonment is lost when the compliance is impossible.
Thank you. I think you have hit on the exact case we needed. So that answers the question for me. You can look all you want, Miss Love, but I think that pretty clearly answers the question. Logically speaking, that was kind of what I was feeling anyway, but now we got case law to back it up. Good deal. All right, so. So I am proposing that if Mr. Melnick is in fact representing Mr. Copeland, I ask Mr. Melnick to please make sure he understands the order, the scope of his immunity, which I read to be derivative use as well, and what perjury means, what false statements mean, what could get him either of those charges, legally speaking. And I know Miss Love, you and Miss Hilton had said there are certain things that even. Okay, well, in your discussions conceptually with Miss Bumpus, but I'll leave it with Miss Hilton, had said, I am not intending to charge you with perjury if you do X, Y, or Z. I am intending to charge you with perjury if you do A, B, or C. And Miss Hilton's not here, but you could speak for the state, I would think, as to if there are certain things that you absolutely know, if you say this, and we know we have proof, whatever you need to establish perjury, that you're lying, then we do intend to charge you, if you know. If you get up and say something that's not material, like, the sky's red today instead of blue. I mean, it's not red, it's blue, but who cares? It's not relevant. Then I'm not going to charge you with perjury for that.
And I think that was along the lines of what the intent was, but the intent isn't really an issue. It's the reading it. I'll just say I agree with what the court is saying about that.
And, if you then say, I don't know, I don't remember, blah, 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 to whatever, every question we ask you, then we will impeach you with prior inconsistent statements. This is what this means. And you don't have to explain that. Mr. Melnick can explain all of that. But I would just propose to make sure that I ask Mr. Melnick to explain all of that. Then he can confirm, yep, we've done that. And then if he has any questions, we'll take questions. And I'm even happy to say, sort of when you get a jury question, we can huddle and go, I'm planning to say this. What do y'all think? If y'all want me to do that, or I'll just wing it either way. If y'all are fine with me winging it, I'll wing it, but don't wing it. Okay. All right. So that's kind of what I'm thinking we do at 3 or 3-ish or whenever we have Mr. Melnick available. And then maybe give him, assuming he is the attorney, overnight to fully advise him of everything. And then we'll have him in maybe first thing and find out what he's intending at this point.
John, I inquired the court regarding the court's earlier statements about the case that Mr. Matthew cited. When it talks about an impossibility, is the court's understanding of that after the trial is over, after this particular portion of this indictment is over, it's no longer possible to purge oneself?
It would no longer be you've said I'd have to have your motion in order in front of you, but as I understand the motion in order at this point, we need his testimony for this trial. Now, you may also need his testimony for some other future trial of some indictee in this indictment. I would think you would need to seek and secure another order. I don't have it in front of me. I can look again, but that's my read on this. I mean, you may never try another person. We don't know that. So how can it not be that, as far as we know, he's no longer able to purge once this trial is over?
Theoretically, given part B of that statute, would he not?
I've made my decision and I get it, but I don't think that, I just don't think that that supports your argument. So I think unless and until you can bring me more law, I'm done with it might mean to this part of it. Okay. All right. So let's go back to our narrowing down, figuring out what needs to be redacted out from these statements of Mr. Zachary.
Your Honor, may I inquire one more thing? If Mr. Melnick intends to not represent Mr. Copeland, what is our position at that point?
I guess we can ask him, does he want an attorney? And I have inquired, because I don't know the answer, of the public defender's office, whether in a kind of situation like this where you have somebody who could have been indicted, who's not currently indicted, who's been given immunity, assuming he would qualify for their services, could they or some conflict attorney provide representation?
Judge, I would tend to agree that seems to be the most sensible thing to do. I mean, at any point where someone's liberty is at issue, the court should at the very least inquire as to whether or not there's representation that can help a layperson, Mr. Woody is, navigate his way through these things. So I would agree with the court's inclination.
Okay. And if for whatever reason, a public defender or conflict defender cannot represent a witness, although I would think they could because of what you said, as long as they qualify, his liberty is potentially at stake, then, but if they can't for whatever reason, then I don't know, we just have to.
Then I would suggest that the court take it upon itself to do the best the court can to advise the witness appropriately without any input necessarily from either party. The court is less vested Mr. Copeland's testimony in either side. And so I think it would be the court's responsibility at that time.
What's certainly ultimately my responsibility, but I am soliciting from both sides whatever they think would be appropriate to advise him about. And I can then take it all and look at it and put it together. I'm not saying just because y'all asked for it, I'm going to advise it, but I would like your input on it, particularly given issues that have been complained about his prior advisement. So,
good.
All right. Okay, so let's turn to, somebody needs a bathroom break. So I know we just got back here 30 minutes ago. Y'all should have gone to the bathroom before then, but we'll take a bathroom break quickly. I'm just going to stay here. right, are we ready to turn to our potential redaction report? Should I take silence as a sin?
How about resignation? Because
Yeah. Fair enough. All right. So. And whenever Mr. Snellman joins us, we'll just take a pause and let some deal with that. All right, so we're now going to be on page. We're now going to be on page 75, lines 10 through 78, line 1. Hearsay about who shot at Woody and who shot Boo, and I'll have to look at it. Oh, and by the way, I was, going to circle back and listen and look at the video on that one item, and nobody, to my knowledge, sent me the video, so I haven't been able to look at it yet. Can y'all?
I've uploaded, I've neglected to inform the court, I uploaded that Dropbox link for recording. So.
I don't know if I still have that Dropbox link. I don't know. Can you just shoot me the link again?
Yes, Ron.
Okay.
I try to keep the same link for the transcript, so I will resend that link. And then there's one long version of the video, and there's a smaller one where it breaks it into smaller chunks. I've used DLC to operate. I don't know if the court has that player on your system.
I think so. I think we have that one.
I will resend that, Your Honor, right now.
All right, great. Thank you. Okay, so let me.
I recommended that you send smaller chunks, so the bigger chunks have a harder time.
Actually sending, yeah. All right. And is this hearsay?
So, Judge, what did you,
So we're at 75 line 10 through whatever the next thing is, 70, where are we? 78 line 1.
So I don't have any objection to 75 line 10, where Dennis says, what'd you hear about them when they tried to shoot Woody? All the way down to line 17, no objection to that part. But when Quindarius Zachary starts talking about, when he says, oh, you talking about where they got shot at, and then Dennis clarifies when they made this post the following day, Zachary says that's when their spot got shot up. That was the next day though, you're right. And when I think it could be seen a number of ways, but when he says Woody went to the hotel party and basically Kel got locked up when Moochie's mama's house got shot up, and Zachary says, yeah. And Dennis says, right. And Zachary says, yeah. If that portion is being offered for hearsay, if that portion is being objected to on the grounds of hearsay, I would say that that's just a matter of showing the proper foundation. And I would ask that that not be excluded before that foundation is properly laid. If it can't be laid, if we don't lay it, then we don't try to get it in and we don't backdoor it in any way. So I would object to lines 18 through 23 on page 75, lines 1 through 6 on page 76, And as,
Okay, well, I mean, that all seems to kind of be like the question on the floor for discussion, right? I mean, they're like saying, okay, what is it we're talking about now?
So, Judge.
Yeah.
Big Boo is someone who's deceased. But, oh, sorry. Big Boo is someone who is deceased, but what they're talking about him getting shot at, that was not what killed him, to my understanding. But this is all just nothing that Mr. Zachary, to my understanding, has any firsthand knowledge of. And then they talk about Woody getting shot at when he went to a hotel party. That case was never charged. I've never seen anyone say they know who shot at him, and this is just more speculation and hearsay. I have no reason to believe that Mr. Zachary was at that party. And then
I withdraw the objection. I'll stipulate.
Okay, so that carries us through all of 76 or
Then-
down through more, it looks like.
well, then they
Through
start.
78, line 1.
Okay, all of it.
Yeah.
Okay. Thank you. So that entirety of what is represented by our number 20 is redacted by agreement. All right, 21, that's page 79, line 14 through 22. Speculation about who shot at Doug's stepdad's house. 14. Yeah, I mean, it's pretty clearly speculation.
We don't have a problem. with
Okay,
that.
so that is out by agreement. So we pick up from there on line 23 down through 81, line 5.
And that's just, Your Honor, Tyreek, I think there's a gentleman named TJ Rivers.
Uh-huh.
I believe that's his last name. He's not charged in this case. And then Tyreek was his brother, and apparently he was killed by someone at some point.
Yeah, I mean,
has-
that all seems just like, they're kind of like, well, while we've got you in here, what might you know about any other shooting that ever occurred?
Right.
Yeah.
It has nothing to do with this case, as far as I know.
What say you, Ms. Love?
I have no objection to, I'm just gonna go down the list, the latter, page 79, 23 through 24. I have no objection to, page 80, the entirety of page 80. What are we going to do? And up through page 80.
They're saying 81, line 5. Let's deal with that. I mean, that all looks like,
So Slug Trontavious Stevens is a member of YSL. He's already entered a plea in this case. And Quindarius Zachary's association, knowledge of, affiliation with Trontavious Stevens. When investigator Dennis says it went quiet for a little while, and then Mr. Zachary, that is, gives this explanation.
Is
I
that
can go-
supposed to
I
say?
can- I can go without that. So
All right,
1 through
so-
5 I'll
Okay,
stipulate.
all right. Thank you. All right, and then our next thing is so that one's incomplete, it looks like. 81, line 13 through 82, line what, Mr. Sharp?
I think to the end of 82. Oh, well. You know, I would say 82 line 6. Or actually 82 line 3. I don't really have a strong opinion about it. I just, my problem is when the police start talking about ballistics and this matching this. I mean, if it's relevant, that information obviously can come in if it's relevant and you know, fulfills all the other requirements, but that would come in through a GBI expert matching ballistics, not through
Yeah,
investigator Dennis sharing information with Mr. Zachary.
yeah. Okay, so Ms. Love?
I have, if it is, and Judge, I apologize, Mr. Atkins just apprised me our server's down, so he wanted to get my external drive to share those,
Okay.
videos with you.
All right.
So I was.
That's okay. So we're talking about 81, line 13 through 82, line 3, and
No objection to the rest of 81. So from line 13 down, no objection to that. So 13 to 23.
No, yeah, through 82, line 3.
No objection.
Okay. Thank you. All right. Now we are looking at 83, line 18 through 84, line 21.
That's already been agreed to.
Oh, perfect. Okay. We're looking at 88, lines 1 through 13.
So, Your Honor, let me be clear. This is my understanding. Mr. Zachary, after I read this and then I've since read his other statement. I reviewed them both. I should
Right.
say. I've read them before, but I was unclear if Mr. Zachary was claiming to have been present at the club compound incident. After reading the first in time, second in that I reviewed statement, it's clear to me that he does claim to have been at compound.
Okay.
My understanding, but there seems to be a blending of what he saw versus what he was told, because my understanding is at some point he flees from the area. He is definitely, by his own words, not on 285 when Lil Wayne's bus is shot. So he can testify, or he has firsthand knowledge, presumably, about things he saw while he was there. But when he says Pee Wee ain't do the shooting, he wasn't there for the shooting. And when he says, I know who left and went behind it though, and he says DK and Shannon. So he's saying Walter Murphy, who's entered a plea deal, my client, went behind Pee Wee's car, Jimmy Winfrey's car. So to the extent that he has firsthand knowledge of things, I concede that he can testify to what he saw, and anything he has firsthand knowledge of that is inconsistent, if he had in fact had firsthand knowledge, he can be impeached. But there's certain things that he speculates, or maybe someone told him, I don't know, but it's not clear to me. So Pee Wee didn't do the shooting. That's a conclusion. He did not witness the shooting. He did not witness anyone do the shooting. So I think that's inappropriate.
Okay, so that is 88 lines 1 through 3, basically. And even the police are like, yeah, we know he didn't do the shooting, so.
Well, people in Cobb County would be interested in that, but.
Okay, well, I don't know. I mean, maybe they're just saying that to see what he's gonna say.
But then he says, I don't know who was exactly in the car. I know who left out and went behind it though.
Yeah,
So to the extent that if he witnessed a cars
Right.
leave compound, I get it.
right.
But beyond that, things that he did not witness, that's what I'm
I
objecting.
understand. So I'm trying to kind of take it piece by piece, because you're saying he cannot say with certainty Pee Wee did not do it unless Pee Wee was with him at the time.
Amongst themselves.
Okay, do you have any basis for,
Well, the portion of it where, so Mr. Zachary, like Mr. Copeland, makes assertions about, the shooting itself and who was doing what. And the way that the shooting happened is a person is driving down the road next to a bus. And in order to be able to both drive the car and shoot the bus, from the way that both vehicles are positioned, you would literally have to have one hand on the wheel, and it was a precarious kind of circumstance that would be needed for the driver of the car, who is Mr. Winfrey, to also be able to at the same time fire the gun and shoot the bus. So in as much as it reflects his personal knowledge of all the people who were there and what was going on, we would argue that his assertion that Pee Wee didn't do the shooting would be subject to a foundation that, you know, we would seek to lay, and I can't say that we have laid that part yet. I think that he is just saying he didn't do the shooting. He was a party to the crime, but he didn't do it. He was driving. He couldn't have. But
so is Mr. Zachary in a second car that's involved in this?
so he is in another car, but he's not shooting. He's not in that.
He's not in the shooter car, but he says, you know, me and these other people went the other way. So he's
in that compound.
right.
Everybody shows up at this one place where
Yep.
the lane is in about 5-6 different cars.
Okay.
And 2 of them at least follow the tour bus.
Okay.
He is not in one of the ones that follow the tour bus.
Okay. But he's there when you have reason to, you have evidence that will support that he was there to be able to say at least that as to the car that wasn't, as to some car, the car that went behind it,
And
that he saw who was in those cars?
yes, he
Okay.
says, Mr. Zachary says, I know who left out and went behind the car. So he
Yeah.
says, and the fact that he's asserting he can't Shannon, if he's crossed on that, I would argue that goes, it's weight, not its admissibility of Mr. Sharp.
Okay, but yes, and thank you. But I guess what I'm at, or what I'm trying to get clarification on is Mr. Zachary, it sounds like from what he's saying is he's there when everybody kind of goes in whatever direction they're going. And you're saying that that's his basis of knowledge for who's in what car, right?
Yes.
Okay.
Even at the point where, like in line 14 of page 88, he's saying, me and Marquavious, went the other
Right.
way. Yes.
It sounds like that's all kind of contemporaneous that they're leaving out. Okay, so then I get that there is a basis on which to believe that he has firsthand knowledge to be able to say, I know who left out and went behind it. Who was that? Well, here's who it was. But coming back to the Pee-wee ain't done the shooting, if that's something you want in, then how does he know that? What's your basis for him being able to say that?
At this time, I wouldn't even proffer it. So I would agree to it unless something is said that changes.
Okay.
Because I don't have, there's never been a time where I've heard him say,
Okay, so then by agreement then, well then why do we need 2 and 3 and 4? Because they're just confusing without line 1, right? So 1 through 4 are out by agreement. So then 5 through 13, well, 5 through, how about
but 5.
How about that? I mean, the 5 through 9, I see as kind of a one little answer that he seems to be able to know. They say truth was with them. Well, and then what about that part?
I don't mind 12 through 13 coming out.
Okay. Okay.
So we're at, the next one is 90, page 90, 11, page 90, line 11 through 90, line 14.
Correct.
Those are words of the police.
Oh, Mr. Melnick is here now. So he's not here on the Zoom, virtually here. Do y'all all have the Zoom link? I mean, you're welcome to, I see that'll show up on, does it show up on that big screen? All right, so y'all can just watch it on the big screen.
Are you ready for me?
I am. I think I say yes, and yet I think I need to probably turn my camera on. There we go. Hi, Mr. Melnick.
Good afternoon, Judge.
We can't get enough of you. All right, so the reason I have asked again for you to join us, and thanks for doing this by Zoom at very short notice, but so I have essentially determined somewhat with agreement of the parties that we are just going to start over with Mr. Copeland, and he has an immunity. There is an immunity order in place. He has immunity protection. And I plan to bring him in and find out what he wants to do. And I would like for him to be counseled. And I just had him in here a couple of hours ago and asked him if he had an attorney. And he seems to think that you are his attorney still. And so I'm checking in with you to find out whether that is the fact, either still or again. Whether you're going to be representing him, because I'm looking for somebody to just ensure that he is properly advised of what the immunity order means, what he could face contempt-wise, what perjury means, what inconsistent statement means, the typical things you would want to advise your client who's going to be a witness in a criminal case.
Sure. So I've talked to him about all that stuff.
Okay. And so are you his attorney currently?
I am his attorney. Yes.
Okay. All right. So, and you're representing that you have in fact already advised him of all of those things.
Yes.
Okay. All right. So I would propose to, unless he just wants to come back this afternoon. I mean, I did think I told him to be available maybe 3-ish. But if you want to be with us by Zoom, but are you available tomorrow to be here in person? If we can have him here in person, that way, if he does have questions as anything's going along, and we're not going to take testimony. I just want to find out tomorrow, does he have any questions? Make sure we clear up a few things and then, you know, find out what his intent is as to whether he's going to testify in this trial or not. We're just essentially going to wipe all of what he already testified to and start over.
Your Honor.
He should be there right now.
Okay. Oh, he's here right now. Okay. Apparently he's outside. Yeah. So do you want to just stand by with us? And if he has any questions?
Sure.
Okay.
And Your Honor, before he's brought in,
yeah,
I would object to him being asked at this. I'm gonna just talk loud. Your Honor, I would object under all of the circumstances for a number of reasons to him being asked at this point whether or not he is going to testify. There have been he's made statements. Obviously, the state has brought him in as their witness to proper testimony against people in the courtroom. Mm-hmm. And he's made representations, true or false, he's made them regarding concerns that he has. He's made them in previous interviews with investigators, not just you. Okay. So, Your Honor, in the interest of not having sort of the opposite effect on him, and I'm not suggesting the court would, I'm just suggesting that perhaps asking him at this point might have a
when do you propose I ask him? Because if you're, I don't know exactly what you are suggesting, and I could be entirely off, but if you're suggesting that he has, are you suggesting he has safety concerns?
Well, he has made statements about people being willing to have him killed. Okay.
All right. Well, to the extent that those might be any of the people currently on trial, he is at some point going to have to sit in this witness box and say, with all of the defendants present, yes, I am going to testify because y'all are forcing me to because of the immunity order, or I do not care, throw me in jail, you know, essentially. So that's going to have to be in open court in front of everybody. So if that's your objection,
it was just the timing of it.
So would you rather I do it Friday? I mean, what, I don't understand what it is you want me to do.
It was a preference, but I'm going to, of course, defer to the court. It's just, you know, as I work through everything that I know has taken place, I'm just trying to make certain that the interests of everybody are protected.
Okay,
I'm not trying to create a.
No, I understand, and I mean I'm just not sure what else. I can do it at a later time, but I don't know what that gets us really, other than more uncertainty. And I also realize he may say one thing right now and then another thing right before he is brought out in front of a jury. You know, I don't know. We can still check with him again because we are not at this point having a jury in here tomorrow. So at the point when we get to a jury, if we get to a jury again, then I can ask him again to make sure. I think that would probably be advisable, but everybody's here right now. So I would propose that we do this kind of right now. But before I bring him in, does anybody have anything they want to make sure I make clear with him?
Not for me, Judge.
Okay. So Mr. Melnick, you weren't here when we had our discussions about what was the outer limit of how long the court could hold him if he chooses not to testify. And it is my belief that the longest he could be held would on contempt would be through the end of this trial. So if you need further discussions with him, let me know that.
I don't think so, Judge.
Okay. All right.
And Your Honor, and I know Mr. Melnick obviously knows how to do his job, but he wasn't, and I don't know how much he's reviewed the transcript.
Let me actually ask him, have you reviewed that transcript of the June 10th ex parte?
Mostly. I haven't. I can't say I've sat and studied every single word of it, but I've mostly reviewed it. Yeah.
So, I mean, the defense believes, and I don't necessarily disagree, that there, in addition to a different interpretation of how long he could be held, there is currently a different interpretation of the correctness of the advice about statutes of limitation. And we also think it doesn't ultimately matter, because what is protecting him should he testify to something that he did that's criminal is not whether a statute has run or not anyway. It's that he has immunity. But it's possible that a couple of, every statute that you could be worried about has run is not accurate. So, I think you were aware of where in there they said something about a statute, and you're probably aware that there are things he could still be charged with. And does he understand that not every statute has necessarily run on everything he might be criminally involved in, but it doesn't matter because of this immunity order? Or I don't know whether, go ahead.
Yes, Your Honor.
Okay.
He understands.
All right. And then, are you confident that he has a sufficient understanding of what might subject him to a charge of false statements or perjury?
Certainly he does.
Okay. Anything else y'all can think of on either side of the aisle? Okay.
Yes, Judge, can we inquire as to whether or not Mr. Melnick, and I'm sure he has had an opportunity to discuss with him any potential federal ramifications he may have in regards to his testimony here?
Okay. And I my interpretation of the immunity order is use and derivative use. But of course, we're not the feds.
And Your Honor, the court has every ability to do this, but I would object to counsel for the defense.
I've asked them to raise anything that they think we ought to be thinking about. So, I invited them to say that. So I don't know whether you want any additional time, having heard that potential issue, Mr. Melnick.
Mr. Copeland and I have had enough time to talk.
All right. Okay. Is there a screen where he can actually see Mr. Melnick over there somewhere? Okay. Thank you. All right. Let's go ahead and get Mr. Copeland in.
See you later.
All right. Hello again, Mr. Copeland. Your attorney, Mr. Melnick, is with us by Zoom right now. You can see him on the video screen and he can see you. If there's any time you want to talk to him privately, let me know that. And I know y'all have had an opportunity since you and I spoke this morning from the bench and the stand to talk about the fact that the state is not interested in you pleading the fifth, and in order to avoid you pleading the fifth, they have secured an order that says you now can be essentially compelled to testify because we are acknowledging that anything that you say, we cannot prosecute you for a crime other than perjury or false statements based on something that you might say that would otherwise incriminate you if it weren't for this immunity order. And if knowing that you still choose not to testify, the court can and will hold you in contempt. And what happens in that event is that you go to jail. And the length of time that you could be held in jail for, if you don't change your mind and say, okay, I guess I will take the stand, is through the end of this trial. I don't know how long it's going to last. I think previous projections had been February or March of next year. I don't know yet, but I guess that's not outside the realm of possibility. But it would only be through the end of this trial. It would not be through the end of whomever else might be severed from this case and tried later. And I know Mr. Melnick's talked to you in more detail about that. So I want to see if you have any questions of the court about that.
I didn't understand. Now you said at the beginning.
Didn't understand anything. All right, so.
No, I'm saying like, I heard you, but I don't know what you're talking about.
Okay, so tell me what it is that you'd like more information about.
You said something about what they said about immunity?
Yeah.
What you mean?
Okay. Does anybody, I think I've got the order. Mr. Melnick, have you reviewed the immunity order with him?
Oh, you saying it's the same from last time?
Hang on a second. Yeah, the same one as last time. Yeah. This one. So that's the one I'm talking about. And that is still in effect.
So you're saying that changed?
It has not changed.
All right.
So what has changed is, it's my opinion that I cannot hold you in jail if you refuse to testify beyond the end of this trial. I think you had maybe been told something different earlier, and I don't think that is.
So I ain't got to wait till every defendant that's not here.
Correct. But you would, if you choose not to testify despite this order, you would potentially be held in jail through the end of this trial, which might be February of next year, might be March of next year. I really don't know. It ends when it ends. And the state has 100 more witnesses, and I don't know, any defendant might also have witnesses. So it could take a while, but that would be the end of it, would be the end of this trial. Okay. So do you have any other questions? Okay. And do you want to talk to Mr. Melnick anymore about this particular issue?
No.
All right. So I'm going to ask you right now, because I'm planning to have the jury back on Monday. And I am going to tell them, we would essentially start over, because I want you to have a voluntary, to an extent, choice and knowing choice, whether to take the stand and be questioned and cross-examined or not, knowing that if you do, other than if you lie, as Mr. Melnick's discussed with you, and it's something the state knows and can prove, they could charge you with perjury or false statements, but they can't, if you incriminate yourself about another kind of crime, they cannot use that to charge you with a crime. And they can't say,
Well, can I speak?
You can, yeah, if you have
I have told the state I have lied and lied and lied and lied.
I know. And
so how are they going to be able to question me?
I mean, that'll be their problem. That's their case to make or not make. I mean, that's not for you or me to worry about. So
they said they're going to be able to charge me if I lie. Like when it's up to them to choose when I'm lying.
Not prior. You've said you've lied and lied and lied in every, I don't know what you've said, but let's even say you've said you lied in every statement you ever gave to the police. If you get on the stand and say that again, or if you say, all right, this one was the truth, that one they cannot charge you with perjury for, because those are things in the past. What they might be able to charge you with is, I don't know, I mean, give me an example of something that you know he didn't do, and well, maybe not, never mind, don't do that.
Can I give you an example for what they told me?
Yeah, yes. And then I'll see whether that's what I think or not.
So
Yes.
she said that the only reason she won't lock me up, I just want to know if it still applies. She
Okay.
said if I do two things, if I plead the fifth and I say that I killed Donovan Thomas.
Okay.
She said if I don't say them two, she will not lock me up.
All right. What was the first one?
Pleading the fifth.
Say it again.
Taking the fifth, Judge.
Taking the fifth. Okay, right. And you can no longer, so taking the fifth means I might say something that gets me in criminal trouble. I might give you evidence against me that you could then use against me. That's what it means to take the fifth, is say, I am not going to give you evidence to use against me to charge me. When they give you that immunity order, immune just basically means we can't do this anymore. It's like if you get an immunization, oh, I'm not going to get the measles now, right? Because I'm immune from it. Because it's like getting you a shot that says, I can say, I can admit to a crime on the stand, they can't charge me with it. They have said, you no longer have a privilege against self-incrimination because we have committed to not being able to prosecute you, not being able to bring criminal charges against you because of what you say. We cannot take that evidence and use it against you. We can't take that evidence. If you say, well, I committed some crime, here's what I committed it with, I buried it in the yard. They can't go dig it up in the yard and then say, well, we've got this. They can't use any of that. So that's why taking the fifth at this point would get you in trouble. Being held in contempt is what we
So what if they don't
formally
have
call it.
they facts together? Like they saying something that they don't know what they're talking about, and then they ask me about it.
They can ask you about anything they want to. If in your answer you admit to a crime, they cannot charge you with that crime. Now, if you admit to a crime and they have evidence that is pretty certain that you did not commit that crime. For instance, somebody gets robbed yesterday and they have proof that you were in Europe yesterday. There's no way you could have committed that crime, but you say, yeah, I committed that crime yesterday. That was here in Atlanta when they know you were in Europe and they got video of you in Europe and you sent a postcard that said, I'm having fun in Europe. That would be proof that you're lying. And so that they could charge you with perjury for, okay? Or false statements for.
Okay.
Okay? So what I want to know from you is when we have the jury back on Monday and you're still under subpoena, so you're still obligated to come, and I'm asking you now, when they're like, all right, we're calling Kenneth Copeland, are you going to say, okay, ask me what you want to ask me. I'll tell you whatever I'm going to tell you. Or are you going to say, nope, I don't care if you throw me in jail. I'm not saying a word. I am not getting on the stand.
It depends on how I wake up.
Okay. All right. Well, then we will just revisit it on Monday morning. So plan to be here at 8:45 on Monday morning. You're free to go for now. All right, Mr. Melnick, please be with us at 8:45 on Monday morning. Can you do that?
Okay.
Thank
I'm
you.
on a trial calendar with Judge Barwick, but I'll notify her what's going on.
All right. Thank you. Appreciate it. All right. So there we have our answer to the extent we have an answer. We will revisit this on Monday morning, which is, by the way, when I plan to have the jury back. And we at least, I have some degree of confidence that he understands what his choices are and what his consequences are. Okay, back to Mr. Zachary's testimony. Everybody good? I mean, I know we just took a break. Anybody need a break before we dive back in again? Yes, all right. I didn't take a break before, so I could use one now. Let's take 10 minutes. Be back at 3:05. Okay. All right, so I think we are on page 90, lines 11 through 14. Okay.
That's law enforcement speaking, basically saying that how Shannon involved in everything. So when they hear his beef, it's almost like call Shannon. That's the detective.
Mhm.
And then the other detective follows it up with Shannon, the shooter.
Yeah.
Now, I will say on page 90, line 14, I should add this. I've reviewed all these statements and I've written notes where I feel that the transcript is insufficient. In my notes, I have on 90, line 14,
Mhm.
Underwood, investigator Underwood says Shannon, the shooter. And then Dennis says because, and then Underwood says Shannon, the shooter again.
Okay.
So that's my objection, is the police
All right.
labeling my client the shooter.
Well, the answer is good for your client.
I understand that, but I just,
But yeah. All right. What does the state say?
Your Honor, it's a question,
No.
it's not an assertion.
No.
They're asking is Shannon the shooter, and the inflection given by any person repeating it wouldn't do as much justice as listening to it.
Well, I will happily listen to that as well. But even if line 17 is a question that is saying Shannon the shooter,
Right.
then we probably could just go with line 17 and not like the 11 through 16.
So.
What do you think?
So 11 through 13, we would object to being excluded because that's Detective Dennis asking of Mr. Zachary something about one of the defendants currently on trial based on Mr. Zachary's relationship with him and affiliation with him. I don't have any objection to 14 through 16 coming out.
Okay.
That's what they want, but we would ask that the court, I think Mr. Atkins has had an opportunity to send the link to the, no, he hasn't. He said it's taking 31 minutes.
Yikes.
So I may be able to, I don't know if.
I mean, if y'all have it and could just pull it up, I can listen to it right now.
then also bring it to you.
Talk into your mic, please.
On line 21,
Yes.
Investigator Dennis, my notes say, where it says indiscernible, says about that action.
About that action?
Yes.
Okay.
Speaking of Shannon.
Let me ask y'all, are y'all actually providing a transcript to the jury when you play these statements?
I believe we may have done it once, not with everyone, but I did intend that we clean up the ones that we have and provide a copy to the defense and see if they disagree with any
Okay.
cleanups and allow the jury to use the transcripts because they tend to prove helpful, but that we hadn't gotten to the cleanup part yet. We haven't cleaned it up entirely, and sometimes if the defense has a transcript they'd like us to use and like us to use, we welcome that as well, but right now we're using it.
Okay. And I don't know if the defense would have any kind of a position on whether on that issue.
There's a lot of issues with these transcripts, a whole lot, and just in all honesty,
Okay.
Your Honor, I don't see how we could agree to a transcript without all of us just sitting in here and
Well,
going
yeah.
through with a fine tooth comb.
No, I agree. And it may come to that, but it may be, a lot of times I think when audio video is played, at least in my courtroom upstairs, there are a lot of times when it's hard to hear. It's kind of like muffly. Even if I take it in my office and listen on my computer and I can hear it crystal clear, for whatever reason, once it gets out here and gets played through, whatever, it's not as clear. Now, maybe down here in 1C, it's a better audio video system and everything's been clear. But I guess if it comes to it, we'll sort it out then. But
Judge, I can, on behalf of Mr. Williams, I can tell you at this point that we're going to object.
like I hear this voice who is talking. All right.
It's God.
Yeah.
No, I can tell you now that on behalf of Mr. Williams, we're going to object to the jury being provided any transcripts.
All right, and
what's happened so far?
What would the basis of your objection be?
It's been our experience thus far that we just have significant disagreement with the state on the transcripts that they've provided thus far.
Okay.
And we think, quite frankly, it's better for the jury to make their own determination about what's being said.
Okay. All right. Well, and I mean, it just may be that as we go on, if and when one day this trial wraps and a jury is deliberating, they may want to hear a whole lot over again, and we'll just all have to sit here and listen to it too. So y'all know that, and if that's what happens, that's what happens.
And Your Honor, we would also posit that there is the instruction that the court could give the jury about the transcripts not being evidence, and that they are indeed supposed to listen and take what they hear versus what's written on the piece of paper as
Sure.
evidence.
Yeah, I mean, so I just was raising that to find out, had y'all already come to any kind of an agreement? What was the practice here with this trial? So it sounds like if you want to do that, first off, you need to endeavor to the extent possible to come to agreement on what a transcript says. And then second, if it's necessary, I will sort out whether I'm going to permit that or not. And I'll listen to the legal reasons for or against. But okay, so if you can tell me, I know that first thing you gave me 27 minutes, 30 seconds. So for this one, where would I be listening? Oh, we're going to play it here. Never mind.
We need the Zoom link.
Oh, it's the same one as it was a minute ago when Mr. Melnick was on.
Okay.
And for this, because the only sound appears to be coming out of those two little strange white speakers, can y'all turn one my way? And I think that may be the subject or the reason for the squelch, but I'm not going to be able to hear it otherwise, unless somebody wants to come up with a little speaker that I can have up here with me.
Judge, could the court give me just a minute? I'm trying to get it open and then
Yeah.
trying to get to that point.
Okay. And as long as we're going to do this, we might as well listen to both of the ones, and I don't care which order we do it in, but Y'all can go ahead. I mean, look, is the video matched up with the audio when y'all are showing video in court, or is there a lag?
Sometimes there's a lag if we use a server, but if we do it from a hard drive.
Okay,
it tends
so
to-
that's what y'all been doing, is using a hard drive?
We've done both, and
Okay.
that's what happened.
All right. What are we gonna be doing right now?
A hard drive.
Okay, perfect. Because honestly, sometimes it helps to see what they're saying in addition to listen. What is this? What is this? Transcript. Which one are we targeting first?
The one on page 90,
Okay.
I'm just trying to get. So where we are, the line he's at right now is the line 25 on page 89.
Okay,
So if I may, I'll just.
sure, that's fine. Yep.
Dang, Slug right now. Just take care of him.
So Slug ain't go on the bus yet?
Nah.
Why
I
not?
told you he grew up, he even on that. He got jail, he hadn't grew up, even really on that no more.
But you said Shannon. How Shannon get involved in everything? So when they hear it speak, it's almost like call Shannon. Because that's what it says because
Shannon too. Now, Shannon always be quiet.
right.
He did. Yeah.
He's scared.
Yeah, he should.
When it comes down to it, he's not scared.
Who shot Shannon? They say he smoked. I don't know. I was locked up.
All right.
It's just jail. I read through jail.
I heard what I need.
Okay.
That's definitely a question. Shannon the shooter? And then the answer is no. He's quiet. So 17 is fine to be in.
Can the court remind me of the one before?
Yes, so that was with regard to item number 13. And y'all said it was around 27 minutes, 30 seconds. And I'm wondering, and we may need to play more of it than that, because I was asking, who is the they that they're talking about? And I was just gonna maybe listen a little bit in front of that. But then, so anyway, that was the issue there. So I don't know how much we're gonna need to listen to find out who the they is. Or if we can find out who the they is. But your item number 13, which was on page 54, but I'm thinking we need to go find the beginning of whatever this portion of questioning is. There's a whole lot of days in here.
I think that it would be helpful for the court.
To just have the whole, listen from the beginning. That's fine. I'll do that. That'll be my homework.
Does the court have, or Ms. Percival have a thumb drive? Because I can easily just copy it onto that thumb drive. That's probably the easiest thing to do.
Probably not here, but definitely in my actual chambers. We've got one. Maybe Miss Bugs could bring us one down before we finish for the day. Okay. All right. So I think that answers our on our number 25, which was page 90. We were gonna, by agreement, strike 14, 15, and 16, because you can't hear what they're saying anyway. But leave in, not by agreement, leave in 17 and 18. All right, so okay. All right, that takes us to 92, line 11 through 94, line 22. Dennis, who's Dennis? It's investigator Dennis. Okay. So. Okay. So it's not the entirety of 92. That's just to give me context. Is it is it 93 line 21 where the real objection starts?
There's my-
92 line 15.
So investigators.
Oh, if y'all don't mind turning those speakers back around now so we don't have squelch.
So,
Oh, Matthews, bring around the corner. Bring around the corner. It's,
Thanks.
yeah, and it's trying to this. That's good.
Okay.
so investigator Dennis was present. He was working an extra job at Club Compound, and he's already testified. And he's provided live testimony about what he observed at Club Compound. Right here, and I think admittedly in the statement, he's just kind of going off his memory and he's confused. And he's testifying about, not testifying, but he's talking to Quindarius about what he saw.
Right.
And we've already heard from him sworn in court testimony about what he saw that night. And this is, in several of the interviews, he goes into what he saw that night. And I just think it's inappropriate for the jury to get investigator Dennis's version of events through unsworn out of court statements. And they're likely to confuse it with what he said on the stand.
Okay. So can you pinpoint for me on page 92, is there anything? Well, I guess line 15, like.
Right. He's leading into it. He's talking about DK, who's Walter Murphy, and I believe it was Pokey. That's Kai Kendall, and he's actually wrong about that. Fatty is Kai Kendall. And so he's just kind of setting the stage of the people he saw. And then
Starting at where? 15?
15.
Okay. Yeah.
And then he's talking about the gun that
Right.
DK had a gun and he recovered the gun,
Right.
and how he pulled out his gun, and Jeffrey's sister Max took offense to it, and how the gun was put on Dolly. Dolly is Max. That's the same person. It's on Dolly's truck.
Yeah.
And so he's just reliving what he observed that day. And I just don't think it's appropriate for it to be played in an out-of-court statement like this.
What's the state's response?
Your Honor, with respect to the sections about Detective Dennis relaying and receiving input from Mr. Zachary, information about the Little Wayne bus shooting, as Mr. Sharp said, Detective Dennis was there that night, and as he relayed what he saw, Mr. Zachary's reactions are the more important thing. Obviously, the jury has heard Detective Dennis on the stand, and particularly at line 93.
On which page?
I'm sorry.
Oh, page 93, line.
15 through 17, for instance. Where Detective Dennis says, but DK had a gun. I recovered a gun from DK that night. And Zachary says, yeah, I saw that. So Detective Dennis's words impact on Zachary and his responses to them are the more important thing than us trying to have him, as Mr. Sharp said, testify. That's not what we're trying to do. Now, there are parts of these that we don't have a problem, consenting to.
All right, well, tell me what those parts are. or the opposite. Tell me what parts you really maintain you want / need / believe you're entitled to get in.
So starting with taking out, I don't mind page 92, lines 11 through 25.
Okay. Well, that's, so we'll redact that by agreement.
And I'm sorry, I missed what the court said.
I said we'll redact that by agreement.
Page 93. Lines 1 and 2.
Okay.
We would object to page 93. Lines 3 through 9.
Okay, so that you believe should be in.
Yes.
All right. And
that's because as investigator Dennis is talking about cooking dog fatty and DK being like this, Mr. Zachary is making his assertions about who among them was actually there.
so he's actually showing I've got knowledge of this and
That's
okay.
our position.
All right. Any response on the 3 through 9 of 93, Mr. Sharp?
No, I'm
All
fine
right.
with that.
So that is then in by agreement, essentially. All right.
As we go on further down,
And then
I have no objection to 19 through 23 coming out, where investigator Dennis is talking about cookie dolls, not cookie dolls, but DK's gun having been taken.
right. Okay. All right. And so up above then, where he's saying DK had a gun, I recovered a gun. Yeah, I saw that. Is he literally mean, yeah, I saw that on the scene?
Yes.
Okay. Yeah, that seems like that could come in. All right.
So lines 24
Mm-hmm.
and 25 on 93 lead into
Mm-hmm.
page 94, lines 1 and 2.
Okay.
We would object to that coming out.
Yeah, I mean, that seems like that's still the firsthand knowledge.
We have no objection to page 94, lines 3 through 6 coming out.
Okay. 3 through 6.
Actually,
3 through 7.
well,
Or
yeah, 3 through 7, that's fine.
Okay.
Look, lines 8 through 10. In, we would object to that coming out.
Okay.
We we would object to line 11 through 18 coming out. We don't, actually, we would object to line 19 through 25 coming out as well. Specifically, where only that Detective Dennis said lines 19 through 22.
Right.
But then Mr. Zachary gives.
Is sort of agreeing and yeah, okay. All right. Any further argument on basically like lines 8 through 25, Mr. Sharp?
No, Your Honor.
Okay, all right. I'm gonna permit that in.
And so
So is everybody clear on what's out and in, or do you want me to, good?
I'm clear.
All right.
So the next section, Your Honor, is kind of picks up right where we are. And I flagged this because it was unclear to me at the time whether Mr. Zachary was claiming that he was there. But I am satisfied that he is claiming that he was at the compound, but I think we need to review it with the knowledge of where he was at the compound and where he wasn't.
Okay.
What is based on firsthand knowledge versus what is speculation.
Can you speak to that, Ms. Love?
Which part are we talking about?
I mean, essentially like through the 94 line 24, I guess through 96 line 14.
So my first issue is on 94, he says, yeah, she swapped cars with him. With who? DK and Shannon. Okay, if he saw that, that's fine. You know, if he, of course, if the foundation is laid to ever play.
Right.
But then after he says DK and Shannon, investigator Dennis says are shooters, and Quindarius Zachary says, yeah. He wasn't present for the shooting.
Okay.
It's going back to, he has no firsthand knowledge to affirm investigator Dennis's theory. So I would have a problem with lines 1 and 2. And then I have a problem with investigator Dennis, who wasn't present, saying
Right.
Pee-wee in the white Camaro was just a driver. He doesn't know that. So I'm going to start out 95, 1 through 4.
Okay. So I think essentially that one is, okay, this is the law enforcement theory at this time, but
So we're starting on
95 lines 1 through 4. Or, yeah.
At this time, Your Honor, well, I'll put it this way, for open reserve, right? If I ask that the court allow, if we are able to establish that foundation, then I ask that the court, not exclude it.
Okay, and that foundation being the foundation that he actually does have.
Personal knowledge of it,
Okay.
or some other.
Okay. Or, okay. Yeah, so that one is, I guess, a TBD.
And Your Honor, I want to also say, so with respect to Mr. Zachary, he has, and the reason we have some TBDs by some of this is that he has not been the most cooperative person. And I would leave it.
Okay, all right, so we'll just see on that. I understand the objection. I understand that it can't actually quite be answered yet. There's a foundational issue. We'll just have to see. Okay. So then we've got, I guess, what? 6 through 14.
I don't have a problem with lines 6 through 8. But then again, he starts theorizing about who's a shooter and who's not. And he says Troop wasn't a no shooter. He was there though. I think he was following them too.
I don't have an objection to, is that 9 through 13?
Yep.
Yeah.
I don't have any.
Okay.
And then I have a problem with 14 through 22. 14 through 25, really.
And is that same basis, like, how does he know this?
Correct.
Okay. Is that also by necessity TBD based on your frustration with your witness? Okay.
And
Well-
that feeds into, 9 and 6 as well.
Well, I would say 24 and 25, 95 lines 24 and 25 to 96 is really 96 line 14 is all speculation about why Jimmy Winfrey pled guilty. I don't think that's TBD. I think
Okay,
that would be
all right, so
completely
hang on, we've got, I'm sorry, maybe I'm just not up with y'all. So 95, 14 through 23 is TBD, is that right?
That's right, yes.
And then when we start on 24, line 24 and going on, okay. That's. Yeah. I mean, so the objection is on page 96, what lines?
I don't have an objection to 96.
95 line 24 to 96 line 14.
I don't have an objection.
Okay, out by agreement. Okay, so are we now at number 29?
Yes.
Okay. Uh-huh.
So, Your Honor, the context of this is there's a gentleman named Rico Rich.
Mm-hmm.
Is it Rico Rich? Rico Rich. And he ran or owned a studio on Metropolitan that allegedly was also used at times by Mr. Williams.
Mm-hmm.
And at some point, this studio was raided, and marijuana was located at the studio, and I think Rico Rich was charged with it. It was his studio, my understanding. July 15, 2015 is when that raid occurred, and it has nothing to do with this case. And so they're just talking about Rico Rich being upset because his perception that the attention drawn by the gentleman in court led to the raid, and it's just about something that has nothing to do with this case.
All right,
And Judge, if I can just add to Mr. Sharp's
all right.
position, the state, we've actually addressed this previously. The state agreed that this would not come in.
Okay. Well, I will find out what Ms. Love says about that, but I think that maybe Ms. Love hasn't had as much of a chance to study this in detail as she would have liked and as I would have liked. And so, Ms. Love, is that correct that y'all had already agreed that this part needed to come out?
And this part, I mean.
99, line 18 through kind of, I guess, what, maybe all of 100? 100, line 10.
Just one second. So I don't have an objection.
Okay.
Page 99, lines 18 through 23. And I don't have an objection with that.
Okay.
It continues on to page 100.
Yeah, go on to the next page through about line 10. It seems to be the same topic.
So we don't have any.
Frankly, 14, I think, or 15. Right? I mean, isn't that all the same?
15,
Okay.
Right.
All right. And so that would also encompass 99, line 24, which I think we accidentally left out of there. So, all right, by agreement, all the way through 100, line 15.
So
That would be 99, lines 18, 24, all the way into 100, up to line 15.
Right. All right.
now, Your Honor, if I could go off the list for a second, I believe
Sure.
one of my co-counsel has a objection to page 100, line 20 to 101, line 5. It talks about Jeffrey's family, how he likes to be in the hood, and he likes people that are going to be right there with him, same people he grew up with. And then investigator Dennis says, right, that makes you guilty by association. And that's improper. And then they talk about Mr. Bennett's aunt being shot.
Okay.
So, Your Honor, the state has no objection to page 100, lines 24 through 25, but we would ask the court to listen. I think I have a different take on lines 20 through 23 than Mr. Sharp. I don't think he's talking about Mr. Williams' family so much.
He's saying though, I'm saying though, Thug is family. He likes to, yeah, okay. I can listen to it. Do you want me to listen to it right now?
Regardless, it says he's hanging out with the same people he grew up with, and then investigator Dennis improperly.
Oh, yeah, no. She
Yes.
says she's fine with 24 and 25 coming out.
Oh, okay. And then that continues on to 1 through 4.
I think 1 through 4 can come out. We don't really need, that is not additive to the issues that we're on trial for. Okay. Huh? Let's just, yeah, you agreed, so. All right, so then, so 100 line 24 through 101 line 4 are out by agreement.
And then at 101.9, they start asking Mr. Zachary how he would feel if his mother got shot while she was
Okay.
in the bed and all of those things. And I don't think that's appropriate either.
So Judge, based on the court's, being regarding 1 through 4, up through 11 would be okay?
Yeah, all right, well, you agreed with it.
I
All right, so all the way through 101 line 11. Thank you.
I mean, it continues beyond 11.
Okay,
It continues.
yeah,
But Judge.
Yeah.
With respect to the ones after 11, Mr. Zachary is, saying his expressions, I believe, are relevant. I don't think that is the same.
all right.
As 1 through 11.
And when you say his expressions, then you mean like facial expressions when he's
No.
talking, or what do you mean?
What he expresses, they just shot up my, cousin's house. I'm mad, and, I don't disagree with respect to
Yeah, I think it goes.
line 20. I don't mind all of that up to.
Okay, so now we're to 101 line 20 out by agreement.
Judge,
Yes.
if I may, the conversation continues on. It's just well beyond 101. I don't think reference to that incident ends until we get to page 102.
So maybe through line 8
I was thinking
or
18.
19.
Yes.
Okay. Yeah, I mean, yeah, essentially they're saying bad things happen. How would that make you feel? And he's not saying anything other than maybe how he would feel, but you can feel whatever way.
Right.
Aren't these kind of hypotheticals? All right, so through 102 line 19 out by agreement.
Now, the next section.
So the next objection, okay, so that's carried us through 30 and 31 then, okay, right?
Yes.
All right, so we're now on item number 32, which starts on page 104, line 3, and goes to the next page, line 3.
and this is involving the Donovan Thomas case, and
Yeah.
I will say that in the other statement, Mr. Zachary asserts that Mr. Stillwell and Mr. Kendrick made some sort of statements against their interest
Okay.
as to who was in the car. But he never asserts that they told him about these details. And he's never claimed that he was there on Cleveland Avenue when he talks, here he's talking about a gentleman named Kelvin Treadwell, also known as OG Bentley, basically taking the guns and taking the car and
Right.
and disposing of those things. He never claims to have been there, and I don't think anyone's claimed he was there. He claims he was at a kid's party, and I think the state has accepted that. And he's never said that he got that information from Mr. Stillwell or Mr. Kendricks, and I don't know where he's claiming he got this information from, but until that is established,
Mm-hmm.
I don't believe that it's admissible, even as a prior inconsistent statement, hypothetically.
So, Judge, what Mr. Zachary said in his prior statement is that he got that information from two of the defendants on trial now, following the shooting at one point the night of at Mr. Williams' condo, and I believe the next one on the way to Miami. My memory may be a little bit fuzzy on that, but because he corrects one of the detectives when they're saying, so both of them told you at the condo.
Mm-hmm.
And he says, no, one told me at the condo, the other told me on the way to Miami.
Okay.
So our argument is that his recitation of what happened would have come from, he wasn't there, we've never said he was, would have come from the same place that he was made privy to the statements that we caught Nuts Down at, which was at the condo, on their way to Miami, because they were together. And by they, I mean various members of YSL. They didn't all go in one car together down there, but they traveled to Miami in the days after the murder. So
Okay, but this is about Bentley's potential involvement in getting rid of the guns, is that right?
So OG Bentley is alleged to have, yes,
Okay.
gotten rid of the guns after the murder.
Okay.
And our argument would be that Mr. Zachary would not have, he's not the only one that says that. It wouldn't, this collective knowledge wouldn't exist, but for his involvement in the gang itself. So this is another spot where I would say, where I would object to it coming out. But of course, I'm going to follow whatever ruling the court makes.
All right.
And I just want to be clear. I actually agree with Ms. Love's recitation of facts to the extent that he said that he got certain information from those individuals,
Right.
but it's not this information.
Yeah, I mean, it does seem like, I mean, he could legitimately have gotten the information about two other people saying they're involved, and that's one thing, and that's not what this is about. This is about what was OG Bentley's involvement, and did he, get and hide guns? And literally, even on 104, like towards the bottom, and they're asking about, they gave him the guns. He's like, that's what I hear. He doesn't even seem to be saying, hey, I know this from one of my in-gang sources. He's just like, oh, I don't know.
In the 2015 interview, a little bit more detailed and a little bit more specific. He references it. So at the very least, I think it.
All right. So how about if you can Point me specifically to where in the 2015 thing it shows that he actually has the legit knowledge of this, then I'll reconsider it.
Okay.
Okay? All right.
So I'm just gonna put, okay, contingent on.
Yes.
This is, and this would be
All, basically, 104 line, what, 3 through 105 line 3? Is that right?
Yes,
Okay.
104.3 to 105.3.
All right. So moving on to item number 33, which is a little portion of page 105.
So the state has no objection to 11 through 14 coming out.
All right. All right. So that takes us to page 107. Our first
I'm gonna withdraw that one.
34.
Yes.
Okay. And how about 35? We're still gonna sort out?
35?
Yes. Item number 35, which is 107 line 23 through 108 line 1.
I didn't remember talking about that one.
Well, it's in your list.
No, you said we're still gonna.
No, I'm asking you.
Oh, yes.
So that's what we're moving to next,
Oh,
right?
yes, yes.
Okay. Sorry.
I
You're
thought you
like,
were
wait a
saying
minute.
we had already discussed it.
No,
I got it.
no. Okay. All right, 107 line 23.
Just a random discussion about a fight in a club that Mr. Kendricks allegedly got into with a man named Lil Tony.
Okay, does that have anything to do with this case?
What did he have? No, it doesn't.
All right. Thank you, Mr. Shard. I'm asking the state now.
So actually, Judge, going back to 106.
Okay.
So 106 just gives her context of time frame, but from 1 to page 107, line 1, when Dennis is asking,
Right. Is this about the time the beef's kicking off? Okay. Well, they don't have an objection to that.
So it's going back to the gambling house shooting, and they thought the quote unquote the mob did it, but then we find out that apparently Kelvin Watts pillow talk with a young lady led to it being revealed that Kelvin Watts did it. And essentially they're asking, why did you think the mob did it? Why did you mistakenly think the mob did it? Assume. And they're saying, oh, because Mr. Kendrick beat up one of them named Lil Tony.
Okay.
And so I don't know why.
Okay.
and this is all around as Detective Dennis said, this goes back around, this is all around the time that this
Right. So as I understand the objection, it is to, well, it may be a little further up than
Right.
line 23, right?
It really starts on 14. Why
Yeah.
did you think the mob
Yeah,
was
all right. So starting at 107, line 14 through 108, line 1.
So when Detective Dennis asks, Mr. Zachary, why did you think, the shooting was taking place? And Mr. Zachary is telling Detective Dennis, yes, he might be speculating about why they did a rival, party did what they did, but he's also stating that Deamonte Kendrick had just beat up one of them.
But this isn't, I'm sorry, it just for my clarification, this isn't one of the IF people, this is some other group, right?
Where it says why y'all thought tomorrow and then I guess
Phonetic or
phonetic,
something.
right there on line 14.
Right.
If you listen to it, it says why y'all thought the mob was shooting, not tomorrow.
The mob?
The mob. And
Okay,
that's the gang that they assumed. did it.
okay. All right, so why do we need this? What is your position as to why this would be admissible? Line, 14 through the next page, line 1. Hey, man, I mean, we thought for a while it was this other group because of this other beef that had gone down.
So as it relates to 14 through 17, we would stipulate to that. But my 18, where Detective Dennis says, y'all had beef all over the place. Y'all being his acknowledgement as he was telling Mr. Zachary of them as a group.
And Zachary at 21 says, yeah.
Yes.
Okay, so then 18 through 21 seems like that legitimately could come in. And then that brings us then to 22 through the next page, line 1, about, okay, here are the details on this mistaken beef again. So that out, and then just 18 through 21 in. Because it seems like 20, you're okay with that?
So I don't have a problem with, you're saying 23?
22, yeah. Well, actually through the next one line on the next page.
Correct.
Okay, so thank you. Okay.
Are we at 109:23 now?
Yes.
Can we go through the exact?
Yes, so on the ones that I just said, okay, so if we go back to page 107, 1 through 13 are in without any objection. 14 through 17 are out by agreement. 18 through 21 are in over objection. No, was there an objection to that, Mr. Sharp? 18 through 21?
No.
Okay, are in because there's no dispute about it. And then 22 through 108, line 1 are out by agreement. All right.
And then we're moving to line 23.
Yes.
I have no objection to 23. I have no objection to 23 through 25 on 109. And 1 through 13 on page 110.
Okay. All right, which I guess means that if there is objection to 110 lines 14 through 19, is there?
Yes, because,
Wait, so y'all want that out?
no, we won't.
Yeah, so I'm asking the defense.
Well, if 14 through 19 is played, there's going to be no context to it at all. Because it starts with, they've been shooting at each other for how many damn months? And no one's even going to know. The last time we talked, they were talking about
Right, somebody
Nut
else.
and Greedy and
Okay.
Kel being half brothers. And
Right. So,
I mean, honestly, I'd be okay with. I've identified this as hearsay. I don't have any problem with it coming in, to be honest with you. But
okay.
you know, if the state needs to play 14 through 19, I just say play the whole thing and
Okay.
give context.
All right. So then that actually starts with 109, line 23 or no?
Yes.
Okay. All right. So basically they're withdrawing their objection to that. Page 111, lines 7 through 9. Okay. What does the state say as to that?
That Mr. Zachary's response, no, Thug just stopped messing with booty.
Uh-huh.
And the subsequent lines are important evidence in this case. Obviously, Woody is Mr. Copeland. He's the one on the stand right now.
Uh-huh.
I can't.
Yeah. No, and he doesn't object to line 10 and 11 and 12. He objects to 7 through 9.
7 through 9 is necessary because they cause the response. That is line 10 through further down. And it is necessary, it is Mr. Zachary's reaction and response to Detective Dennis's question
It's not a question, though.
between.
Yeah, it is a question. I mean, it might not have a question mark at the end
Well,
of
it says,
it. I mean,
word I got
Right.
is Shannon started putting in more work than Woody. That is a declarative statement, and it gives the impression that other witnesses have told Investigator Dennis that, and that I've never heard someone tell Investigator Dennis that, and
yeah.
even if they had, that needs to be come from the stand.
He starts out with how did Shannon.
Yeah. So the how did Shannon part's really not a problem. I mean, could you redact out after the dash? How did Shannon? And I know we then don't have the word Woody in there, but Mr. Zachary provides the word Woody. No, Doug just stopped messing with Woody.
Why don't we just start with line 9, just with why Thug start pushing Woody?
That works. Thank you. Thank you.
Thank you.
113, line 23, 114, line 3. So do y'all, let me, before we dive into the substance of this, we're not gonna unfortunately get through the entirety of this one statement today. So we can look forward to doing more of this tomorrow. But there are, how many, two other statements? Okay.
I can provide all of them to the court.
Okay. Here's the thing is, I mean, some of this I am having to make rulings on, but a lot of it, it's like, it might be, and I'm not saying it's the first time you're looking at it, but it's the first time you're looking at it for the purpose of trying to think about whether you're okay with redactions. And that's not really the best use of court time, by which I mean time that we are all here between 9 and 5 in court. So can you endeavor, and I know this is a lot, but y'all should have done a whole lot of this before now. So can we sort of maybe by the time we all reconvene tomorrow, have a whole lot more of this sorted out so that y'all can hone in on the things that I need to make an evidentiary ruling on?
I have no problem with that. I know
Thank you.
Mr. Sharp was endeavoring to give us another.
He's got, this list is great because I just need, okay. I need the responses to winnowed. All right, great.
Okay, he gave it to us from one of the other interviews. We need the last one. There's 3 of them.
Okay, well, do you have that one ready yet? Mr. Shart is ahead of y'all on these interviews, so maybe while y'all catch up through the rest of these 2, he can be finishing the 3rd one, if he doesn't have it yet.
I'm trying to remember. I'll talk to the state afterwards. I want to make sure I'm on the same page with them about the 3 different statements.
Okay. So I'm sort of thinking I don't want to do any more of this. How about that? Because y'all can maybe do some things to make it all easier. So I will take a look at the beginning of this video. Y'all, the state, are going to go through what you have so far, which is the rest of this statement, potential redactions, and then whatever the second statement, not in time, but you know what I mean, potential redactions, and have it crystallized more for tomorrow. And tomorrow we also, I think, can't remember what I told you to turn in by tomorrow, but what was it?
John, we do the report exhibit.
Yes.
And I have a very nerve-wracked and nervous person working on that. They're asking, what if we don't have everything?
I'm gonna throw them in jail. I am kidding. I understand this is a monumental task, which again should have been done before now, but given that it wasn't, we're doing the best we can. If they do the best they can, it's not what we're going to be dealing with, but it's not for me anyway, it's for the defense. So to the extent they have whatever they have tomorrow, turn it over, and then the rest of it by Friday. How about that? That seems reasonable. All right, what else?
And also, the court asked us at the beginning of the week to have the next.
Yes, the next tranche. Yes.
Yes. So
where are we on that?
we count even that tomorrow night is the end of the beginning of the week, but I don't know. So we're there.
You're okay. All right. I'll check in with y'all again on that one. Okay. Mr. Harvey is going to produce a potential 105 limiting instruction within the next couple of days before Friday for me to consider.
Will the court give the state an opportunity to?
Oh, absolutely. Yeah. I mean, but we got to have something to at least start with. Oh, y'all are also all supposed to be thinking about what it is that we tell the jury about why we're starting over with Mr. Copeland, which may not, necessarily need to be a whole lot of detail, but we are going to be starting over with him. So it's going to be a disregard everything you heard so far, and then we either hear from him again or we don't. I don't know. We'll find out depending on how he wakes up that morning. But I'm gonna have, that'll be, it's going to be a strike everything you heard, and then we'll see what happens next, But any kind of suggested instruction as to that as well, since we're starting over on him.
Okay.
Yeah.
So you're not talking about trying to offer it up and work it out now?
And no, I think, didn't some people have objection to any of that? Right? I mean, hey, if y'all want to, super, that's easier. But the gist I was getting earlier today was that there were some defendants who objected to that, and that it might be just cleaner to just start entirely over. And frankly, if he ends up, it depends whether he ends up testifying or not. So, I mean, yeah, I'm happy with if he ends up testifying and y'all are like, yeah, we're going to use this day, whatever, all of it, whatever. I don't care. But that's going to have to be because y'all agreed to it.
Your Honor,
Yes.
I thought the people charged here position was, and I think the state's position was just to include the 7th, which really was not anything, and then the 10th, which is Monday, the 12th, which is Tuesday, and part of the 11th, 10th, 11th, and 12th, part of the 12th, but nothing thereafter, not strike everything. There was a lot of exculpatory information on the 10th, 11th.
Here's the deal, though. And if he ends up testifying and y'all want to say those 3 days, great. But if he ends up, since what I am trying to do is sort of circumvent the whole issue of potential coercion and give him an opportunity fully and correctly informed to make a decision about whether to testify, then if he says, no, I don't want to, then that means none of his testimony should come in unless everybody wants to agree to it, which would be kind of, an odd scenario.
If we don't get to cross-examine Mr. Copeland, we would like to strike all of his testimony under
Okay,
that
right?
circumstance.
Yeah, right. So, and then, if y'all want to try to call him as your witness, if anybody's calling a witness, then try that. I don't know. If you want exculpatory parts of it, but then that, of course, comes with risks. So it just, a lot of this is up in the air depending upon. I think if he says, now that I'm fully informed, which I am not saying that any of his decision before was because of any incorrect information. I just think, like he said, it depends how he feels when he wakes up in the morning. So, but anyway, yeah, in order to try to tackle all of the issues surrounding this, this is the best I have been able to come up with. So, so y'all be thinking about that.
Did Your Honor get the thumbs up?
Yes, magically. All right. Anything else before we break for the day?
Not
Early, because I'm going to go do some work on it, not in court.
Just for your edification, we'll file a written motion. The state yesterday gave us a Dropbox link, and it includes additional telephone numbers that I was unaware of,
Okay.
where an expert, he's already been qualified. His name is Agent Bernie, Berni, from from the FBI, has done now an analysis of historical cell site location data. And I'm objecting to that very late, I believe, notice. And then the state has a couple other, they changed charts. I personally don't have a problem with that, but I need to study them. But the new reports and data and a new phone number, I am not agreeable to.
Okay, an entirely new phone number. Tell me some more, Miss Love.
Yes. So the new phone number is, there was another person in the vehicle during one of the murders in this case, that investigators were still investigating during the time we began this trial. They were trying to hash out whether or not this particular person was even in the car, if you will, with some of the alleged parties to the crime.
Okay.
Since that time, during the course of this trial, the investigators with the Atlanta Police Department that were doing their deep dives into forensic data determined that this person, I don't think that person has been arrested, but this person was also in the car with the co-conspirators during this particular murder. We got it before now, but we got it after the trial began, like between, I think, January and now. And I think it was inadvertent that it had not been disclosed.
All right, can I stop you and get some clarification?
Yes.
When you say we got it, do you mean we got this report from this agent, or we got information that there might have been yet another person in the car and that person had XYZ phone number and that was going to be investigated?
So those are two separate things. The report from the investigator, from Detective Bernie, involved plotting.
Sure, I understand what that means. When did y'all get that?
We recently asked him to plot those two, because the green store is a thing that came up recently during trial, and the other location was. So we have two understandings of what the court is asking. So we're not talking about the plotting of those cell phone numbers. We're just talking about the Boyer cell phone records. We're just talking about the cell phone records.
We're talking, I don't know what we're talking about. That's what I'm trying to pin down. So
there was.
Hang on, yes.
We were given cell phone records linked to a last name Boyer.
Boyd, B-O-Y-D?
B-O-Y-E-R.
Boyer, okay.
On Monday, on yesterday?
Okay.
Yesterday. And so that is the late disclosure that we're speaking of.
Okay.
And they were charted as well. Which leads
Nobody
me
really, I'm sorry, do y'all care, is the objection to the charting, or?
It leads me to believe that they've had them for a while if they've plotted them.
All right, so the plotting of the cell site location information report done by Agent Bernie, that's of this Boyer phone number?
Yes.
Okay, and y'all just recently asked for that based on some testimony about something?
No, that's a different thing. I literally sat there and conflated two different.
Okay, all right, so then let's back up to the original issue. When did you find out that law enforcement believed that there was another person in the car and had a cell number that they were going to investigate with regard to that to find out whether, in fact, that was a reasonable lead?
Your Honor, I'd like to check with another team member.
Okay.
Because I don't know the answer.
Can you give me an idea? Let me clarify. You said about something that it was sometime between January and May, and that might have been that you got something. What was that about?
So the conversation that I had with the team member most recently, like 2 days ago, was that I have to turn over these phone records.
Right.
This person was someone that they believe might have been in the car.
Okay.
And they got phone records, and now we know that based on the phone records, this person was in the car.
Okay. So when did they ask for, we or they, not we, but y'all or they ask for the phone records because they thought that might be?
I beg the court to allow me
All right,
to answer.
find that out. And then do you know when y'all got the cell phone records?
When you said we, I thought you were talking about us. I don't know the answer at all for the Atlanta Police Department, but I can find out.
Okay, so unfortunately for you, we equals, y'all equals, the state equals both the DA's office and the Atlanta Police Department. You know that. And I know sometimes there's a little lag in communication, but I need to know, was it, if they were provided to the defense on Monday, was it last week or was it 4 months ago?
Okay, I can find
No,
out. I will-
because, okay. And what do these cell phone records reveal? That this person did appear to be also in the car? And
There's two cars.
okay, do you know which car? I mean, there are two cars that obviously one, well, not obviously, at least one contains at least one shooter, right? Is there any assertion that others contain shooters as well, or just people that are involved?
The state
Okay,
is alleging that there's a white car with my client and Mr. Garlington in it,
Right.
and then another car with Mr. Nichols and Mr. Farley in it. And now it sounds like they're saying that this Boyer phone, whoever owns this phone, was in one of those cars. And I'm inquiring what,
mm-hmm.
I don't know anything
I'd
about
like to provide that information, if I can.
You don't know, you want to check and make sure on that, okay.
Because it was not a part of the original. Yes.
Okay, how long has the defense known anything whatsoever about this person named Boyer?
Your Honor. Oh, except for this, I can tell you from my understanding of the discovery, there is zero information on Mr. Boyer except one mention in a jail call. That is it. That from my whole database, I have one mention. That is it. And I have no reports. So the police been investigating and found out that this person allegedly was involved in this killing. I still, to this day, have no reports on it. I've
Okay.
never interviewed him. I didn't open on him. He could be
Right.
a great defense. I have no idea who this person is.
Yeah, I mean, yeah, this is, I mean, potentially significant information for the defense to know about.
I can't say that at the time we did opening that the police had it. I'd like to be able to say.
All right. All right, we'll find out, but there's been a long period of time between opening and now. 8 months to be,
That was 24, okay.
7 or 8 months. So, yeah, we need a lot more information about this. I love how y'all save all of the bombshells for late in the day, right before we're wrapping. Y'all going, hey, guess what? So, okay. I mean, it is what it is. Okay, so we'll need to find that out and put that on the record and sort that out tomorrow. Okay, so exhibits, next 30 witnesses, and then you also, I believe, we're going to get by tomorrow, actual, like a list to the defense of here's what we think is a co-conspirator statement, right? Okay, so we'll be waiting anxiously for all of those. Anything else? As if that wasn't enough.
Your Honor, somebody I wrote down said that there are 3 Mr. Zachary statements. I have 2.
Okay, and I might have misspoken. Did I misspeak? Miss Love misspoke. Did Miss?
I might have put a date wrong, but I'm talking about 2015. I think it was August 2015. I believe March 2017 and the proper. So it's I'm sorry. I might have misspoken too.
Okay, so you think that maybe there only are 2, but you'll confirm that for us tomorrow? All right, and so if there are only 2, then Mr. Shart, you've done all of the proposed redactions because you've done redactions to 2 full statements, right? Or proposed redactions.
I didn't quite finish the second one, but I don't believe that the state is going to be trying to use it. It's a discussion with ATF agents and.
All right, y'all, we're going to get together and sort that one out too. Okay. Sounds good.
And Judge, if the board needs to finish the court, just allow me to get this thing copied. Judge, I'm not gonna keep you on the bench, so I will have some.
All right, that's fine. That'll work. Thank you. All right, see y'all at 9 tomorrow.
Yes, Your Honor.
We'll be 8:45 at it when we have the jury. Okay. All right, so we're adjourned.